19th.
All right, we'll convene the meeting of the Haverford Township Zoning Hearing Board of Thursday, December 19th, 2019. Present at the front table to my far right is Ken Richardson, a voting member. Good evening. Next to Ken, Bill Rhodes, a voting member. Good evening. My far left, Jessica Vitale, a voting member.
Good evening.
Next to Jessica, Ed McGargy, a voting member. My left, Luke Clark, our solicitor. And my name is Robert Kane. I'm the chairman. Kenny, would you please lead us in the pledge?
Please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we set this special meeting for one case only, and that is case Z19-21, Scott and Lindsay Rockers, owners of 2019 Oakmont Avenue, Havertown, PA, DC folio number 220301699900, who seek a variance from the provisions of section 182-206C6A to allow the construction of a 476 square foot addition and 40 square foot ADA ramp that will encroach into the required 8-foot side yard setback by 20 feet. And 20-foot side yard aggregate total. And the variance provision, section 182-206C5A, to encroach into the required 30-foot front yard setback. Property is zone R4 and located in the 3rd Ward. Good evening. All right. When last we met, I believe Mr. Mezzanani was in the process of calling Stephen Skoke? Shock, sorry. I'll phonetically spell it. And I believe Carl had placed an objection on the record.
Yes, Your Honor. I'll just restate, I understand that you've ruled that he is permitted to testify, but there's no place in the FHA that allows for a neighbor to come in on a zoning accommodation and present some alternate plan designed to accommodate the desires of the neighbor. Yeah. So I don't think the testimony has any relevance, and I think that your board will find that way too.
Just a quick response to that, Mr. Ewald. If you look at the memo that I believe you handed up, there's discussions about alternative accommodations and the interactive process. So as far as I can tell, it is relevant and it's something the board should consider.
Is that under zoning or is that under landlord-tenant relationship?
That's under the FHA, going through the normal.
Sure, but it's two different creatures. It's like, if we're talking about my, minivan at my house, or we're talking about, the SEPTA bus on the street, there's different regulations for each circumstance. I mean, the original Fair Housing Act dealt with the problem that there were covenants to exclude people of certain religions or certain ethnicities from housing developments. And the FHA came in and said that that was illegal and unconstitutional. Now, those cases don't have any bearing on, or don't have much bearing on this case. Just like, a case where in a condominium where we're talking about a common area, of course it makes sense that if you're renting from a landlord and all of the burden of the accommodation is on the owner of the building or the manager of the building, then that person, that entity might have the ability to propose alternates. But in this case, we're talking about a private piece of property where all of the accommodation is located on the private piece of property, and all of the burden, the cost of the accommodation is being borne by the owners of the property. And we have a next door neighbor who's, proposing alternates to an accommodation for a disability to try and, satisfy his wants. And that just doesn't make any sense, and it doesn't apply.
Well, we also have to determine, well, not me, because I'm not voting, but the board has to determine if this may be necessary.
Right, but that's not even a factor in necessary under the zoning. And I mean, if you'd like, I can get into that now.
Well, my advice to the board is they can do whatever they want to. Now, my advice to the board is to, listen to it to create a full and complete record, and they're going to take it for what it's worth.
I
I
understand.
can't control how they're,
Yeah.
what they're going to do with it.
I guess I was addressed, and I'm just, I'm responding to
Absolutely,
that.
absolutely, absolutely.
Okay, so we'll hear the testimony from Mr. Schock, unless someone on the board wants to be heard. All right. John, please proceed. And Mr. Schock, did I swear you at the last hearing? Did we get that? I may as well just do it. Did I?
I think you did,
Oh,
yes.
you were.
Evening, Mr. Schock.
Good evening.
And so just quickly, I'd like to go through your credentials for the purposes of the board. You are a licensed architect,
I am.
and we submitted earlier what was marked as Kenny 4, and you have a copy of Kenny 4 in front of you. Can you authenticate that as a resume reflecting your experience?
It is, yes.
And so let's walk through a little bit of that. You had indicated you're a registered architect, and I think your resume, your CV, indicates that you're licensed in several states. Are you licensed in Pennsylvania?
I am licensed as an architect in Pennsylvania, yes.
And so could you just briefly summarize for the board your professional experience and education?
Certainly. I have a Bachelor of Architecture from Carnegie Mellon University in Pittsburgh. I was first licensed as an architect in 1987. I hold a registration with NCARB, which is a national organization that allows reciprocity in multiple states, and I currently hold active licenses in good standing in at least 20 states.
Have you been practicing as an architect since 1987?
Yes.
Your resume indicates that you have a focus at times on supportive housing. Can you explain to the board what that means?
Certainly. The entirety of my career I've spent at the same firm, Kitchen and Associates. And throughout that career, we deal primarily with housing projects, affordable housing, everything from small group homes to multifamily apartments, affordable housing. And one of the unique subsets of that specialty is supportive housing. That is a term that is used to define housing that is specifically designed for special needs populations to be able to thrive in the community. You probably are aware of many of the institutions for the disabled and such are closing down, and most of that population is moving out into the community. That is one of the catalysts for creation of additional forms of supportive housing, and they take many different forms.
And perhaps you can give board an example or maybe some overview of what specifically you get involved with when you're working with supportive housing in a residential context.
For most of the work that we do, most of the work that I do, I don't have the benefit of working directly with the end user. What we are doing is designing accessible housing for the particular needs of a user group. Maybe folks with physical disabilities. Others may be folks with autism, and they're very distinct design moves that we incorporate for sound attenuation and sensitivity to light and things like that, and noise for those with special needs with autism. With the consideration for physical disabilities and mobility impairments, usually that involves a heightened level of attention to the design for clearances and such to make sure that certainly the standards are set forth, but the standards are basically minimums that are codified. There are certain populations that require moves that go beyond the standards.
And speaking on a personal level, Mr. Schock, can you tell the board about your personal familiarity in your life with the design needs of disabled person?
Certainly.
I don't see how it's relevant. I mean, there's tons of people in prison who've done awful things to women, and they might have daughters. That doesn't make them a feminist. I don't see how his family situation is relevant to this case.
I'll say this, Mr. Schock's an architect. He also has now an adult disabled daughter.
So he's putting the testimony in that I just objected to.
So the question is, did he design the house that his disabled child's living in?
Well, I mean, I can answer that question, but the broader question is, given the fact that he has the professional experience as an architect, given the fact that he has a focus in supportive housing, I think it's relevant to the board to have an understanding of what he brings to his testimony, to know what his personal experience is actually living in an arrangement that requires supportive housing.
Well, he's here,
Imagine it's not relevant.
I mean, my understanding is he was being submitted as an expert in architecture, correct?
I haven't offered him, but my plan is to offer him as an expert in architecture and design of supporting housing and housing for disabled persons.
Yeah, I mean, I think my recommendation would be to keep it to that. Stay away from the personal aspect of this.
Well, in that respect, I could ask him if, Mr. Schock, do you have experience actually living in an environment with a person who requires supportive housing?
I do.
I think that's what was just ruled not to be asked.
This is remarkable to me. I think that there could be nothing that better equips the board for some understanding of what this witness brings to this particular topic than to know what he personally deals with as a parent, but as an architect, in what the needs would be of a disabled person.
This isn't a, go ahead.
This is the focus of this hearing, and if he did this for a client, it would be clearly relevant. The fact that he doesn't have a client relationship with this particular individual doesn't make it any less instructive to him in his understanding and appreciation of what has priority, what's important, what's necessary for a person with disabilities. To me, to parse this and say, you're not allowed to talk about somebody that you have a personal relationship with that involves the very same work and the very same considerations that would be involved with clients, it seems to me to be inconsistent entirely.
So, are you done? This isn't about his daughter. This isn't about some generic person with a disability. This is about the rocker's son, and this is about the needs of the rocker's son. I don't see how his relationship with his daughter has anything to do with that.
This is voir dire on credentials. This isn't substantive testimony as to what may or may not be relevant in terms of the actual matter at hand. It's the question of establishing credentials for purposes of having the witness admitted as an expert witness in these areas. And so we're talking about specific experience in the specific area that's at issue here. So, as a voir dire on credentials, I think it's entirely relevant, and I would think the board would want to know. You're going to be making decisions based upon input from this person who may or may not have what you think is reliable information on what is helpful or necessary for a disabled person. How can you not want to know that?
All right. For purposes of your voir dire, my recommendation would be to allow him to continue.
Okay.
So, Mr. Schock, could you, and we won't go on long about this, but could you talk to the board about your personal experience in your household with the design needs of a disabled individual?
Sure, and my answer will be shorter than the question, I think. I have a 29-year-old adult daughter, lives at home. We've made multiple modifications to our home to accommodate her needs. She needs full assistance with all aspects of daily care. To the extent that it impacts my professional credentials. If I were a doctor, I would have gone into medical research on her issues. If I were a lawyer, maybe I'd have gone into civil rights law. I'm an architect. So I chose within that context to dedicate the majority of my career to making sure that there are the best solutions for folks who live with serious challenges so that they can live in their homes.
Thank you, Mr. Schock. And with that said, so what is the mentality that you bring to these proceedings? You're thinking in terms of what you would want to achieve, what you would want to tell the board.
Why am I here?
Okay.
I was invited to take a look at this case midway after it had started. And in the more than 3 decades that I've been practicing architecture, this is only the second time I've ever agreed to testify on behalf of an objector. And the reason for my agreeing to do this today, frankly, is
I'm going to object again. That's not relevant. I mean, this is more about him making himself feel better about it
My
than
answer is it's
anything
relevant
with the
for
case.
reasons I stated before. I don't want to rehash everything. The board's heard my rationale.
All right, my recommendation would be to hear it.
You can continue, Mr. Shaka.
my only reason, frankly, for agreeing to this is, frankly, I don't like to see people spend good money on things that won't work. And I will go further into that in the professional testimony once I'm qualified, which I don't think I quite am yet. But that's my concern. My concern is not for a side yard violation. My concern is to make sure that this family can actually live and thrive in their home. And I know this is a terrible, terrible venue to do this in. However, it's the venue that we have, and that's why I agreed to do it.
At this point, I would offer Mr. Shaka as an expert in architecture and the design of supportive housing and housing for disabled persons.
I'd like the opportunity for some voir dire.
Please proceed.
Are you being paid for your testimony?
I'm receiving a modest fee, yes.
And did that impact your decision to
Not at all.
testify? But you didn't offer to do it for free, right?
No, I did not.
And when were you retained?
I was retained prior to the hearing on the 5th, a week prior.
Now, you just stated that you have dedicated your career to finding the best solutions for disabled persons. As part of that, do you work with specific disabled persons, or do you only do generic development?
I work with providers who develop housing in the community that become available to those with special needs of various kinds. The housing is developed, and then I work with both the providers, I work with family resource groups, the developers and the funding agencies that create this housing.
So a family like the Rockers that's putting or proposing to put an addition on their house, they're not your clients normally.
Not typically, but I have worked with some special needs clients.
Okay. So when you work with a special needs client, when you're working for a specific person, what's the normal process for you to onboard the client? Do you visit the structure?
Yes?
You didn't do that in this case, right?
I visited the Kenny's home next door, observed the property. I didn't have an opportunity to see the Rockers' home itself, but the Kenny's home, I understand, is of the same basic layout.
But you don't know because you haven't been in.
That's true.
Yeah,
Okay.
I'm going to object to this line of questioning in the sense that I don't think it goes to his credentials. It may go to the weight of his testimony, and that might be cross-examination that's appropriate in that context. Specifically as to his credentials, I'm not sure the specific examination as to what he did in this particular instance goes to his credentials.
Yeah, I think he's right. I think those are points to make during substantive testimony. For voir dire purposes, I think we're getting a little off track here.
Do you have any other questions?
Just 1 second, please.
Sure.
Based on your ruling, I'm going to wait until cross-examination, but I really, part of being an expert is knowing the facts. Part of being an expert and giving, to be recognized as an expert in Pennsylvania, you have to bring something to the table that can help this board more than the average person. I think dealing in hypotheticals doesn't help this board. We're talking about a house. We're talking about a child. We're not talking about a hypothetical building, and we're not talking about a group of, for a category of disabled people. So, I don't think he qualifies as an expert, and I don't think he should testify.
I would just say we're talking about a design that's on paper, a design that's being proposed to the board as what is necessary for this particular individual. And I think that an expert that has some good familiarity with this area of architecture can talk to this design. And so I'll say no more. I think he's eminently qualified in the areas for which I propose.
Unless there's any discussion or objection from my fellow board members? You advise that? Okay. then
I
we'll-
do, and I'll just ask, have you ever been subjected to any discipline or any type of censure by any licensing authority?
No, I'm in good standing on all licenses.
And we'll accept Mr. Schock as an expert in that area. Go ahead.
All right, Mr. Schock, let's talk a little bit about what you have done to acquaint yourself with the matter at hand. Have you read the transcript of the testimony of Mrs. Rocker that she had presented at this proceeding?
The August testimony, yes.
And you were present for the last hearing, is that correct?
That's correct.
You've seen what's been marked as Exhibit 13, which was also marked as Exhibits 1 through 10, which were the architectural plans of Jesse Poynton with some other schematics in there as well?
Yes, I'm familiar with that.
Okay. You had indicated to this in your voir dire, but you've been to the site where the Rockers' home's located, is that correct?
I've been to the Kenny's home. I've not been on the Rocker property.
They're right beside each other, right?
Correct, right
So
next door.
you've seen the Rockers' home.
I have.
And I was going to get to that. You walked through the Kenny property,
Yes.
and were you told that, except for the addition the Kennedys have put on, Kenny's,
Objection that's leading.
Can we ask it again?
I don't know if I finished my question. Well, let me see if I can ask another one.
You were telling him what he was told.
I just said I didn't think I finished my question. Mr. Rockers, Mr. Schock, did you develop an understanding as to the similarities that may or may not exist between the Kenny home and the Rocker home?
I think I had, between the visual exhibits that were part of the applicant's submission and seeing the Kenny's home, I think I have a fair understanding of the physical conditions.
Right, and we'll talk specifically about any understanding of similarities between the two properties and structures.
So that the two structures appear to be of the same width and general layout and plan, same scale. Many of the homes, when they were originally built on that street, appear to be of a similar pattern design.
Have you seen Dr. Slack's letter that was submitted as Exhibit 14 by the applicant?
Yes,
And lastly, you're aware, or you're not, of the existence of an 8-foot setback under the zoning ordinance that is to exist between the Rockers home and the Kenny home?
yes, there's an 8-foot side yard minimum requirement and a 20-foot aggregate requirement.
And so is it your understanding that an issue in this proceeding is whether it's necessary for the Rockers to build into that setback in order to allow Gabe, this Rocker's son, to be able to use and enjoy the dwelling?
Objection, that's a decision of the board. He's not qualified as an expert, attorney on the legislation of the FHA. It's your decision whether this is a necessary accommodation, and that we haven't even laid the foundation that he understands what the standard is.
I've asked the witness whether he understands that in this proceeding, the issue, not asking him to come to a conclusion in this question, but that the issue relates to whether it's necessary for the Rockers to build into that 8-foot setback in order to allow Gabe the use and enjoyment of the dwelling. I think that's been repeatedly stated by counsel for the applicant that that's the issue here, and I'm orienting the board and the witness to the fact that that's what we're talking about.
As long as you're not asking him to provide any conclusions of law.
Well, I mean, the question stands as the question. Do you understand it's an issue? I don't know that necessary will ultimately be a question exclusively of law. You know, I think that it's a question of fact in part, because whether something's necessary inherently involves the question of whether there are alternatives. And whether there are alternatives is a factual question, not merely a legal issue or question. But as to my specific question that's at issue here, I've posed a question to the witness: are you aware that the issue in this case is whether it's necessary to build into the setback? And that's all I've asked at this point.
I think that is the issue, so.
And that's your
Yes,
understanding?
I'm aware that that is the issue.
Okay. You know what, I'm going to
The
do.
objections overruled, just so we keep a complete record.
So, Mr. Schock, I'm going to refer you to what I've marked as Kenny 5 and Kenny 6. Mr. Schock, I
I have
in front of you what's been marked as Kenny 5 and Kenny 6. They're actually stapled together, but the two single pages are separately marked, and I'll identify them separately. Did you prepare Kenny 5 and Kenny 6?
I did.
And just for the record, Kenny 5 is identifiable by the indication of the wording Kenny 5 in the upper right-hand corner, and then similarly, Kenny 6 is identifiable by the wording Kenny 6 on the upper right-hand corner of that page. Can you tell the board, just very generally, what is reflected in Kenny 5?
So Kenny 5 is basically the, using Exhibit A2 that was submitted through by the applicant. And the underlying, all the black text is the underlying applicant's site plan for their design solution. And it shows in a dark crosshatch the side addition that's in question. What is shown in red is an alternative solution, or the site plan expression of a solution that goes to the rear instead of the side. What I was requested to do was to address the question of, do we need to go to the side, or can we, is it possible to fulfill the program that is fulfilled by the Rockers' current design? Is that possible going to the rear instead of going to the side? So this is a site plan illustration that indicates a footprint of a potential alternative that does go to the rear and does maintain full compliance with the setbacks.
And while we're identifying exhibits, could you talk briefly about what is depicted in Kenny 6?
Kenny 6 is a floor plan of the first floor of the Rockers' home, and that portion that is existing is discerned from again, the applicant's materials for their proposed addition. And what this does is it shows potentially how a plan would lay out to meet those things that are programmatically, that have been programmatically stated as the basis for what is necessary for this family to remain and thrive in this neighborhood. Clear circulation, accessible bathrooms, usable bedrooms, a larger kitchen, larger family spaces, and things like that. This happens all on a single floor. It creates both bedrooms on the ground floor, and the purpose of this fundamentally is to affirm that what others have done in this neighborhood, and what I read in the testimony of members of the board asked, the very first one was, can't we go out the back? And the answer that has been given by the applicant has been, no, we can't. We have to go out the side. It's necessary. And this is offered simply to say, not as a design, oh, you should do this, but is simply to say, within reason, that yes, you can go out the back. Yes, you can have all of the elements of your program, and frankly, you can have it simpler and likely less expensive by going out the back. This is a single-story addition that doesn't involve multiple floors of construction, doesn't involve connections with the existing roof. It utilizes the one thing that this property does have, which is a large rear yard. And that's what many of the other homes on the block have done as well.
And so if we could talk in an overview way, and with reference to Kenny 5, which is the exterior layout, am I understanding this correctly, that what is depicted as the possible addition is a single-story addition out the rear?
Correct.
And just as a overview, although it may be obvious given the fact that we're looking at the underlying proposed plot plan by Mr. Point, are the improvements that are proposed all within the side yard setback?
Yes, they would be.
And just as well, they're also within the rear yard setback, correct?
Yes. In fact, the rear yard setback is further back on the site. It's shown on the underlying exhibit. It's actually back towards the garage.
Can we walk through the Kenny 6 just a little bit so that we have a good appreciation of what is available as an alternative design? So I think it might be useful to start from the top of the exhibit and work down. So you have as I see it at the top of Kenny 6, depicted a sort of two-bedroom suite arrangement. Can you talk to the board about what that design element is, what's behind that design element?
Certainly, and this also goes to some of the things that have been entered into testimony through the various hearings. Some of the concerns that have been stated here is that there needs to be close proximity to monitor Gabe when he's in his bedroom. To have just a single bedroom to the front of the house doesn't allow for another caretaker, whether it be the parents or whether it be a paid nurse or something like that, to be able to do that within close proximity. They would be separated by a full floor. A two-room suite is a very common way to overcome such a thing, so that you would have two bedrooms next to one another to maintain the privacy of the individual, Gabe in this case, and also provide for 24/7 a place immediately adjacent to the sleeping area. The bedrooms also are of a proportion that is more appropriate for folks that have challenges, mobility challenges, and may have wheelchairs, and in this case, the intention is for a motorized wheelchair. Motorized wheelchairs are actually larger in footprint and require a greater turning radius in many cases than a standard wheelchair does. Frankly, that's one of my concerns with the bathroom area in the applicant's design, their current solution. It's a very small bathroom with just a 5-foot turning radius. Many power chairs, which is the intent here, I fear it will not be able to turn around in there, and there's no way to make it any bigger. More than that, one of the things that needs to be recognized and is that the purpose of the ADA and the purpose of those clearances, they are designed.
Objection. He's not an expert in the purpose of the ADA.
He hasn't been offered as attorney or an expert under the ADA, so I'd be inclined to,
I can restate. How's that?
why don't we give that a,
Okay. In the commentaries that go with the ADA's, these design criteria, they're contained in a separate document called the ADAAG, the Americans with Disability Act Architectural Guidelines. It gives you the basis of the discussion and how those decisions are made as to what is an appropriate turning radius and a reach range and things like that. All of these criteria presume independence of the individual in a wheelchair to go in, manipulate the wheelchair, and then self-transfer with sufficient upper body strength from chair to toilet, from chair to shower seat, and such like that. These clearances, in my experience working with some very, very challenged populations, are insufficient when people need assisted adult care in those bathrooms. Many a time you will need for an adult who may be able to get their chair in, but you'll need one, maybe two adults in that bathroom with them in order to help them make the transitions that are necessary. Those floor clearances, frankly, are not sufficient for the basic functionality like this. If you have a person as it is reasonable to believe from what has been entered into testimony about what Gabe's challenges are, it is likely that he will not be able to self-toilet. That means a bathroom in a custom home.
Objection, he's speculating as to what Gabe's condition is when he's never even spoken with his mother.
I'm going off of the testimony that was already in the record.
It's essentially based on what's of the record, particularly the correspondence from the physician as well as the testimony that we've heard so far. We understand that Gabe has little body control. We recognize that the hope that he will use a wheelchair is founded on that he's going to be able to maneuver his head and neck, but he otherwise has spasmodic body control. I think it's pretty clearly established here that the record reflects a very, very limited physical independence. Have this witness taking into account what the testimony is and then matching design criteria to that testimony, I think is perfectly appropriate.
I think you allow it.
Overall, go ahead.
Where I was going with that is that many bathrooms for individuals with this type of adult-assisted situation require also a adult-sized changing table, a place where hygienic care can be done that's not a toilet. This is simply something like an exam table in a doctor's office or something like that. These things require space. They require forethought and they require space. And this is are some of the things that, quite frankly, I don't believe work in the current design that the Rockers put forth. So towards the back, you have a shower, which is 6 feet in distance. That's big enough for both the person being showered as well as an adult assist. It's large enough for a changing table and things like that. That's about the smallest that for somebody with this criteria, to be made aware of something like that, this is about the smallest bathroom that I would think would work. And it's almost twice as large as what the applicant's current plan is. And I believe that to be a concern, especially when it's being put forth as the only thing that will work. And I don't believe that, quite honestly, that it does.
Mr. Schock, talk a little bit about the data that you have that appears in red just beneath the legend Kenny 6. So you have called out some numbers there, and it may be apparent to the board, but I'd like you to recite what the significance of those numbers?
Those are simply some statistics that put forth that the size of the new construction of the addition is 692 square feet. The rebuilt deck is 240 square feet. The minus 347 represents that deck and patio that currently exists that would be removed, ultimately confirming that the increased impervious through a rear yard addition, as opposed to a side yard addition, would be far under the 1,000 square feet that is the threshold for the stormwater management component.
And does your proposed design contemplate any removal and relocation of the driveway to the other side of the house?
No, the driveway can remain where it is, the curb cut can remain where it is.
You've indicated, I see, a arrow that runs vertically with arrowheads at both ends that appears to be in the center of the depiction. Could you talk to the board about what that indicates?
There's been some discussion about the necessity for a separate dedicated hallway to the side. In fact, that is the element of the current design that encroaches on the side yard. The purpose there being a clear area so that Gabe in a wheelchair can be able to navigate through the first floor of the house. A side yard or side hallway basically gets you to a point of entry to those rooms, and then there has to be a clear path through those rooms. That red arrow, the tall red arrow, indicates a very clean, clear, centralized spine of circulation directly from the rear bedrooms, past the bathroom, the kitchen, the dining area, through both of the living spaces. So it's the most efficient and the cleanest and straightest way to get through a house or through any space. One of the other considerations in doing this is to understand that in the event that Gabe cannot use that wheelchair and needs other assistance, there are things called Hoyer lifts. These have to be anticipated and designed with structural support to be able to help one individual safely transition a person from the bed into the chair, or from the chair into a shower seat, something like that. These things, they're basically ceiling tracks and a system of cables and belts and such like that. They work best when they're in straight lines. They're most effective when they're in straight lines. And being able to lay out a home with a single straight line of circulation is by far the most efficient and convenient way to do that. And when you're doing it in primarily a new construction, the new construction can be sized and designed to accommodate that weight.
And the further comment that you have sort of in the middle of the page in red with an arrow pointing to an area references existing one-story area to be rehabbed or removed and replaced. Can you address that with the board?
That's simply an indication. The dark dotted line indicates the existing back wall of the house. Most of it, over by the kitchen, that's a two-story element. What's shaded in red is existing one-story element. One-story areas, quite honestly, I don't know the condition of that foundation. I don't know whether it's better to save it or to remove it, but it's a one-story area. In either case, that would be something that would be determined by whoever the design professional is that assesses the final outcome, and the contractor in debating back and forth whether that's more cost-effective to build around that as a one-story or to replace it.
Mr. Schock, can you talk about what would be anticipated as disruption if there is a construction of what your design proposal concept would involve, as opposed to the disruption, need to leave the house, et cetera, that might be involved with what the Rockers design?
Well, any kind of residential construction requires some disruption. To minimize disruption, what you want to do is have something that is as simple as possible. And the simplest thing is to build as much as you can outside the existing footprint and then make your connection. In a concept such as this, the entire new kitchen, the entire new bathroom, all of that can be done in the new addition without disrupting any of the existing systems or any of the existing bathrooms, any of the existing kitchen. And then the transition can be made in a very limited way in that red shaded area once the majority of the work is completed. That can't really be done with the two-story addition, which requires reconfiguration of the stair from the second floor to the third floor, reconfiguration of the upstairs bathroom, reconfiguration of the kitchen within the existing footprint. A lot of that is happening inside the existing home as it is.
And is there any characteristic of the design proposal that we've been discussing now that you have depicted on Kenny 5 and Kenny 6? Any characteristic of those that, in your judgment, would have a positive cost consideration as opposed to what the Rockers design involves?
I think we need a foundation to show that he has the experience and the training to make that kind of determination.
Let's just ask you as a foundation matter, not trouble you with the ruling of the objection and just lay a little foundation. Mr. Schock, are you familiar with design elements that make construction, as a general matter, not talking about nickels and dimes, but as a general matter, less costly, and design elements that, on the other hand, will tend to make construction work more costly?
Yes, fundamental to every project is making decisions that are reflective of the client's budget.
And is the nature of an addition sometimes an influence, as a general matter, on what cost considerations might be?
Yes.
And so talking specifically about this one-story, rear-only design that you've depicted in A5 and A6, and contrasting that with the design elements of the Rockers' proposed design, are there any characteristics, as I asked, of the design that you have reflected in A5 and A6 that would tend to have a positive impact on cost considerations?
Yes, and I believe this is also consistent with the testimony heard at the last hearing by Mr. Papa, where things that are simple cost less generally than things that are more complicated. The fewer times that you touch a building, the simpler it is. The less rehab that you do of an existing building, the fewer surprises you're likely to get. As a predominantly new construction with a minimal connection on the first floor only, not touching the roof, not touching the upstairs plumbing, not touching any of the existing systems that are embedded in the existing house, it is basically a standalone. And on a level of simplicity, it's at least equal to, if not less than, the complexity of the applicant's design solution.
Mr. Schock, I think we probably have finished with Kenny 5 and Kenny 6. Is there any aspect of Kenny 5 or Kenny 6 that you feel we haven't addressed that you think it's important that the board know about?
No, I believe we've covered it.
Mr. Schock, I presented you with what's been marked as Penny 7. And you recognize that as a 4-page exhibit which has red ink or red colored markings on each of the pages that superimpose on the exhibits presented by the Rockers, the first page being overlaid on Exhibit A4, the second being overlaid on Exhibit A5, third on Exhibit A6, and lastly, overlaid on what I believe is A1. Or rather, I'm sorry, A2, forgive me. Do you recognize that?
Yes, I do.
And do you recognize that as a architectural concept, the overlay design, that is a concept which takes the spaces reflected in the Rockers' design, sort of realigns them within the setbacks?
Yes, this is an earlier alternative design that was done by another architect that also reflects a design strategy to remain within the setbacks.
And just as,
At this point, I'd just like to first clarify who that other architect was. And if it's Mr. Deeming, I would argue that this testimony is inappropriate. There was an agreement between the parties that Mr. Deeming would not appear as a witness against them. And to take his work and have someone else parrot it is having him appear as a witness against them just through someone else's mouth.
I don't intend to identify the identity of the architect. I think what's relevant here is that it's a proposed architectural plan. We have an architect here who's not Mr. Deming, who can speak to the fact that it represents yet another alternative design, and to talk about what is involved in that design and its availability as an alternative. There is, to the extent that there's a private agreement that a certain person won't testify, that certainly is not being violated. Nobody has called that individual as a witness, nor am I otherwise planning to call Mr. Deeming as a witness.
Was the agreement placed on the record here? Let's see, I don't recognize that. So these are not, so none of this is your work here?
It is
that
not.
correct?
It is not.
And you ought to know, and this is sort of related to what we had talked about at the last hearing, which was reflected in Penny 3. It's the concept fleshed out. So I think this is already in concept come before the board. It's just that what the board saw was a bare bones, rough and ready sketch, and what the board is seeing now is a more complete version of that. So, there was a lot of testimony about Kenny 3. This is the Kenny 3 concept with detail added, and for that reason, I think it's additionally relevant.
You reference,
Maybe I'm a bit old-fashioned, but it seems to me disingenuous to say and to agree that you won't have someone testify and then have someone else read what is essentially their testimony. I mean, I guess if the board's inclined to allow it, then they'll have to weigh that in the, in how they evaluate the honesty and integrity of the witnesses.
I would just say, and I think that that was meant as a slight toward me, that I very intentionally did not identify anybody as the author of this particular plan. Its origination, of course, in this equation is because the witness identified by the applicant, Mr. Papa, talked about alternatives, and he spoke specifically about two alternatives. One alternative he talked about was dismissive of, an alternative that was in concept, this concept. And so having brought it into the equation, the applicant, through its witness, Mr. Papa, now is suddenly saying that the neighbors, the Kennys' lips should be sealed about this, and we're not in a position to talk about the very concept that was brought into the equation by Mr. Papa. I think that would be grossly unfair to the Kennys.
I think they're perfectly able to talk about Kenny 3. Kenny 3 is a document that was provided to the Rockers and requested of the Rockers that they go out and evaluate the cost of constructing Kenny 3. They did that, and they reported those costs to the Kennys, and on the eve of the last hearing, they received this new third and or fourth, or second and or third version of an alternate plan. And now, on the eve of this hearing, they received a fourth version of a plan, and frankly,
I'm not sure I understand the math. It's 1, 2, 3, 4 versions. So, and I don't know that the board needs to be focused on what happened outside its record. But I will say this to the board. Kenny 3, as I indicated previously, was prepared, and the expectation was that it would be fleshed out by the Rockers architect and costed. It never was. So in follow-up, what we presented to the Rockers, and we've done it, it's almost a month ago now, were the fleshed out version, so that would be available to the Rockers. It looks like they haven't troubled themselves to cost that out, relied instead on the rough and ready sketch of Kenny 3, which to me is really almost unusable. So we have a concept here that has been through two iterations, one, the rough and ready, and two, this refined one. And it all comes back to the same question that you've been grappling with, which is, are there alternatives? And is Kenny 3, or the matured version of Kenny 3, a reasonable alternative and a viable alternative? And I'm not bringing Mr. Deming in to say that's the case. And I said I wouldn't bring Mr. Deming in. But I have a witness here who is an architect, who, just as we can look at Mr. Poynton's plans and opine about them, can look at any other plan and opine about them and say to you, we have something here that is viable. And the notion that somehow the Kennys have pulled this out of their back pocket is just not true. As I said, it's been a month or so that this has been in the possession of the Rockers.
2 weeks, the night before last hearing.
All right. All right, so my recommendation would be to allow it and give it its due consideration.
And Mr. Schott, so just let's work our way quickly, if we can, through what's been marked as Kenny 7. And so we look at the first page there, and that is a overlay on top of Exhibit A4. Fair to say?
Yes.
And sort of taking into consideration that the focus here is here on the setback issue, what kind of a design plan does this propose as to both the setback issue and to incorporating the elements of the Rockers plan into another configuration to maintain those elements, but to order them differently.
So what this plan effectively does, it still has a side yard addition. It's just not as wide a side yard addition. The hallway that is in the applicant's plan remains, and the bathroom has been moved to the front, shared with the bedroom. This is taking programmatically what was in the Rockers plan and moving it around so that the side yard encroachment no longer exists. You have only a 4-foot approximately addition as opposed to an 8-foot approximately addition. I'm sorry, it's a 9-foot addition that's been proposed.
And as that design would be configured, I take it that the driveway would remain in the current location on that side of the house.
There would be sufficient side yard left to alter the traffic flow in the driveway, but that it would stay on that side.
And the legend indicates that there is 225 square foot of addition.
That's what it says.
And looking at that, does that appear to be an accurate summary of what is laid out here?
I haven't verified the calculations, but it seems reasonable to think that calculation would be close.
And then just moving to the second page, which is the overlay onto Exhibit A5.
So A5, what that does is, in addition to the hallway on the side yard, there's a more modest rear addition on the first floor and on the second floor to create the additional bedroom that was part of the applicant's plan.
The concept generally then would be a 2-story rear addition and a small 1-story side yard addition.
That's correct.
And then does the third page, which is the overlay on Exhibit A6, just indicate the roofing elements of that design?
That is correct.
And then finally, the fourth page is that an exterior view of the different design elements that have been overlaid as detailed in the prior pages of the exhibit.
That's a plot plan or a site plan expression of how this would work, yes.
We've talked about the design that you did that is Exhibit A5 and A6, and we've now talked about the design that's reflected in what's been marked as Kenny. Forgive me, I think I referred to the exhibits as it's a Kenny 5 and 6, and what's reflected in what's been marked as Kenny 7. Does that in your mind represent the limited universe of possible designs that might be effectuated within the setback to address the Rockers' needs, or is there a possibility that there could be other designs as well?
There could be others.
And in terms of, like that, Mr. Schock, do you have an opinion to a reasonable degree of professional certainty as to whether the Rockers can reconfigure their home to accommodate the needs of Gabe as have been expressed in the record, without intruding into the 8-yard side yard setback, 8-foot rather side yard setback between the Kenny property and the Rocker property?
Yes, I believe that is possible.
And is it your position that your plan that's reflected in Exhibit Kenny 5 and 6 and the design plan that's reflected in Kenny 7 are two plans which are an example of alternative designs to address the Rockers' family needs that do not require intrusion into the side yard setback between the Kenny property and the Rocker property?
Yes, these are two alternative examples.
I don't have any other questions for Mr. Shaw.
Okay, Mr. Ewald. If you want a few minutes, that's fine.
I think I'm okay to go. So your testimony, if I understand it correctly, is that you were approached by the Kennys and you were so moved to help the Rockers that you immediately signed up to be paid by the Kennys to submarine their application.
That is the way you can characterize it.
Yeah. So did you ever consider reaching out and calling Mrs. Rocker?
I was instructed not to
Okay.
by my
And-
client.
By who?
By my client.
Okay. And did you ever consider reaching out to me?
No.
Now, what was your directive in developing these plans?
My directive in developing these plans was to determine if a viable alternative exists to fulfill the program represented by the Rockers design without violating the setbacks.
Now, you testified, or, I'm sorry, and in that directive, if there was a option that would be superior but did violate or did intrude into the side yard setback, would you have been permitted to offer that?
That wasn't part of my directive.
And hypothetically, as an architect who's done a couple of additions for, persons with disabilities, can you imagine a superior alternative to all of these plans that includes an intrusion into the side yard setback?
As an architect, I can imagine a lot of things.
So your directive was to find a way to show, or find a way to create an addition that satisfied the needs of the Kennys.
And the needs of the Rockers.
Okay, so when you say you want to satisfy the needs of the Rockers, you didn't visit the Rockers' house, right?
That's correct.
You didn't conduct any measurements at the Rockers' house, right?
That's correct.
You didn't examine the structure to see how it would tie in, right?
That is correct.
You didn't talk to the Rockers.
That is correct.
You didn't ask the Rockers what their goals were, right?
That is correct.
You didn't discuss with them what the disabilities of their child was, right?
That is correct as well.
And did you talk to the Rockers about their budget?
We'll stipulate to the fact that as.
No, I think this
testified,
testimony is important.
I think we've established to nobody's disagreement that Mr. Schock never talked to the Rockers, but if you want to ask about every single topic they didn't discuss, the board can hear it.
Well,
Did you talk to the Rockers about their budget?
No, I did not.
What budget were you given?
I was only given the cost information in the cost estimates that the Rockers submitted.
So when you say there's other options depending on your budget, right?
Always, yes.
The bigger the budget, the more options?
The bigger the budget, the more addition you can do.
So when you complete a set of plans, would you normally show them to the owners of the property and get feedback on whether they work for those people?
Certainly.
But of course, you didn't do that in this case.
No, that's outside of my, my contract.
And did you show them to the Kennys to see if they worked for the Kennys?
Showed them to the Kennys, yes.
And did they make revisions
No,
or propose revisions?
no.
Do you know what the name of the person with the disability is that you're designing an addition for?
My understanding is his name is Gabe.
Good. When did you create the drawings that you presented tonight?
over the last 2 weeks.
And when you were here to testify 2 weeks ago, what drawings were you going to present?
I believe they were, this is Kenny 7. I was only prepared to speak to Kenny 7 at that time.
And why did you change your mind?
I had more time.
When did you finish this drawing?
I finished this drawing 2 days ago.
Which?
Kenny 5 and Kenny 6 were completed on Tuesday.
Do you know what equipment is necessary or needed by Gabe at this time?
Not specifically, no.
And you testified that these are just hypothetical drawings, they're not actually meant to be built?
The design portrayed in Kenny 5 and Kenny 6 is an example of a hypothetical, a design that I believe fulfills the programmatic requirements as embodied in the applicant's design.
And now you testified that you believe the Kenny's property is largely similar to the Rocker's property. Is that a correct assessment of your testimony?
Yes, it's largely similar.
But that's just speculation, right?
Informed speculation.
Now, you testified that you thought that your design had characteristics that would have a positive impact on reducing the cost of the addition, right?
I believe so.
Does your design have characteristics that have a negative impact on the cost of the addition?
I don't understand. If I believe that the design has positive cost implications, it has either positive implications or negative implications. I believe there are positive implications. I can't have both.
Well, your testimony had characteristics that had positive impact.
Yes,
Would you agree that there are some characteristics that have a negative impact?
if by negative impact you mean may cost more than the Rocker's original design, yes. For example, I include a laundry on the ground floor, which is not currently in the Rocker's design. Or a laundry on the accessible level is a very convenient thing if it's achievable.
Well, and just simple things. There's more roof, right?
There's actually less square footage than the Rocker's original design, but it's used more efficiently to create larger spaces.
Now, you testified about what was marked as Kenny 7. In making your evaluations of that drawing, do you know where the electric service is for the house?
No.
Do you know where the plumbing stack is?
Excuse me?
Do you know where the plumbing stack is?
Plumbing stack? No.
Do you know where the entrance to the third floor is?
No.
So if I would tell you that those items, excuse me, that the design proposed in Kenny 7 actually blocks the entrance to the third floor, you couldn't tell me whether that's true or false.
I can't, and that's frankly one of the reasons why Kenny 5 and 6 go out the back, because all of those existing things are untouched.
Now, you've seen the plans prepared for the Rocker's application, right?
I have.
And you've expressed your concerns about them.
Yes.
Does the creation of or is the bathroom despite your concerns, does it comply with the ADA regulations?
No, it does not. That said, the ADA regulation does not apply to single-family homes. So it embodies one aspect of the ADA regulation, which is a 5-foot turning radius. It doesn't provide for the various adjacencies and clear spaces next to the toilet that are also embodied in the ADA regulations.
Which may or may not be relevant to Gabe's condition.
It may not be. And as I said, ADA doesn't really apply to single-family homes. The door swing and the door clearances also don't comply with the ADA.
Does the creation of a bathroom that's compatible with the use of a shower chair assist in allowing a person who needs a shower chair to use and enjoy their home?
Yes, it does.
And does the creation of a dedicated hallway to allow a disabled person to access other rooms of the home allow for, or does that improve or help that person address the needs of their disability?
It is certainly a requirement to be able to navigate through the first floor of the house, yes.
And does the creation of a bedroom that's designed to house both a safety bed and all the medical equipment, including possibly a lift, as you mentioned, does that assist and ameliorate the difficulties that are encountered by someone with a disability requiring that equipment?
Yes, that's a reasonable design consideration.
Did you do the building coverage calculations on your own design?
Only on the net square footage of the addition and the comparison of that versus the area currently occupied by the deck and patio.
Okay, I'd like to talk about that a little bit. Can you put that exhibit up?
Kenny 5? That's the plot plan.
No, the other, Kenny 6, please.
Okay?
So Kenny 6 shows essentially a 20-foot, 8-foot rectangle, or 20-foot, 8-inch by 40-foot rectangle with a little, I don't know what architecturally you would call that, butt out. I don't know what you would call that. What would you call that?
A little projection,
A
that's fine.
projection, okay. So, and the projection is approximately 5 foot 4 inches by 12 foot 4 inches, right?
Correct.
Okay. And in your calculations, you remove from that calculation the area that's outlined in red, right? In red dashes?
No. That's why you have to really look at Kenny 5 in order to understand the calculation. The 692 square feet of the addition is that area in red. That's just new construction. The 240 square feet of the new deck is the deck. The area being taken away, the 347, is the existing deck and the existing patio that is underneath.
Okay.
The idea is to get a net increase in impervious to be sure that it is not in excess of 1,000 square feet.
Okay, I'm going to get to impervious later. I think you actually agreed with me, but unwittingly. What I meant to ask you is, your calculation of the additional space created by the addition is the area in red, right?
Correct, correct.
And when I asked you about the 20-foot, 4-inch by 40-foot rectangle, essentially, this space here, you removed from that calculation because there's already...
Because that exists, yes.
Okay. So, it just struck me because, looking at it, I know 20 times 40 is 800. So, I did a little bit of math, and I found that, I won't write on your exhibit without permission, but this rectangle, which would include the new space plus or not including the portion that sticks out, is about 826.8 square feet. Would you agree?
Yeah, 20 by 40 is 800.
And this space here, that's approximately 5 foot 4 inches by 6 foot 4 inches, that would add an additional 33.7 square feet, right?
You are correct. There is apparently a math error.
So would you agree with me that your addition is not 692 square feet, it's actually more like 820 square feet?
That actually sounds about right. I'm not sure how the math error happened, but apparently there is a math error.
Okay.
Thank you for bringing that to our attention.
When you did your evaluation of this proposal, did you consult the zoning code?
I did not.
Okay. So would it shock you if I told you that the maximum building coverage on this lot would be 30%?
I have no reason to believe otherwise.
Okay. I mean, if you look at, I don't think it's in front of you, but I'm going to hand you a copy. This is what has been previously labeled Exhibit A1. The Kenny's architect did do calculations, right? Can you tell me what the existing building coverage was or is?
What this reads is 1,455 square feet.
Okay. And do you have any reason to believe that's not true?
I don't have any reason to believe it's untrue.
And the existing lot size is 7,143 square feet, right?
That is what it says on the plan.
And you didn't do any independent research on that?
No.
And would you agree that with the finding of the architect that the maximum proposed building coverage is 2,143 square feet?
Again, if I have no reason to disbelieve the numbers, and I have not independently verified them.
So if you take the 820 square foot addition, the 877 square foot house, and the 200 square foot deck, I didn't include the square foot proposed addition proposed by Mr. Schock. The 877 square foot original house, and I didn't include the ramp in the calculation. I only included 200 square feet for the deck. And then 317 square feet for the garage. My math would say that that's 2,214.5 square feet, which is basically 31% building coverage.
I haven't done the calculation. I have no reason to believe yours are inaccurate.
Okay. But you made no effort to make sure that this design that you were proposing wouldn't also need either a variance or a accommodation.
The parameters of my directive was to see if it was possible to do a rear addition that did not encroach on side yards.
Okay. Now, you also testified as to your interpretation of the impervious surface coverage, right?
In terms of the relative increase between what exists and what the addition would be,
Right.
yes.
And your testimony was that your addition wouldn't require stormwater, enhanced stormwater management applications because you had a 692 square foot addition, which we decided is not accurate. It's more like 820. You had 240 square feet of decks and ramps, and then you subtracted out the 347 existing deck, square feet from the existing deck and patio, which you're demolishing, right?
Correct.
And your testimony was that brings it below the 1,000 square foot threshold, and therefore you wouldn't have the increased stormwater?
Yes, that's my understanding.
Okay, and what's that understanding based on?
It was based on prior testimony and reading of the record.
Okay, so you haven't done any independent reading of the ordinance?
No, I have not.
So if I told you that the Haverford Township Stormwater Ordinance does not permit you to subtract removed impervious, then that would make your addition over the 1,000 square foot threshold, right?
Forgive me, you're posturing that if you remove impervious and put new impervious on top of that, the impervious still is doubled?
It's not doubled, you're just not allowed to subtract what you removed. I mean, it's the stormwater ordinance says specifically that you have to include all new and reconfigured.
I guess the ordinance is whatever it is, and if that gets submitted to the board can consider it.
Can I just ask a question on your line of questioning, just about the decks? Are you including in this analysis the decks as impervious?
My analysis, well, yes, both this architect and the other architect did. Your ordinance doesn't specifically provide for the exclusion of decks. But my testimony, or my questioning on the deck specifically was regarding the building coverage. And your building coverage under your ordinance specifically says that anything appended to the house and attached to the ground is included in building coverage. So certainly it would be a deck that would be covered by building coverage. Did I answer your question?
Yeah, my point is I don't think that we generally have treated decks as impervious in impervious coverage analyses.
So certainly if you don't treat them as impervious in an impervious coverage analysis, you can't subtract it from removing it, right?
Both ways.
Yeah.
Right. I agree. I'm just saying that I know that you're looking at what might be the implications of this Kenny 5 or 6 with respect to other zoning rules, but I thought that if we went to questions on impervious and you're doing your calculations, I think we would have excluded that, both calculations, existing and future. If that helps.
Yeah, I mean, I don't have the ordinance in front of me right now.
I think I would ask Kelly, but I think that that's how we treat it when we have looked at other projects, generally when we look at decks.
Yes, when we do calculations for any permit, we subtract any decking, so long as there isn't a patio or gravel or anything underneath it, from the impervious calculations. It is, however, in building coverage calculations. Whereas patio, so long as there's no footings and it's not able to be built on, would be included in impervious, but not included in building.
Okay. Thank you. I'm sorry, did you say you watched the video from 2 hearings ago, but not all of the videos?
I read the transcripts from the prior hearings, other than the one on the 5th, which I attended.
Okay. And could you tell me what the elements of the building design were that the Rockers valued?
The elements of the, as I understand, this goes more to the testimony from the August hearing, when the design was presented. I believe the things that were valued were clear circulation, the ability to have a ground floor bedroom and an accessible bathroom on the ground floor. There was also some discussion about the additional bedroom because of the expanding family.
So, do you remember the testimony about not a clear circulation, but actually a dedicated hallway?
I do recall those words being used, yes.
Okay. And do you remember why that was a priority?
I don't have I don't have the testimony and such in front of me, but I believe one of the concerns was to ensure that there were no obstructions on the floor.
Right, because Gabe can't call out and say, hey, your Legos are in my way, or, hey, Dad, you didn't push the chair back in on the dining room
Yes.
table, right?
That's reasonable to, from what I read in the testimony.
But you decided that wasn't valuable for your design.
I didn't say that it wasn't valuable. The length of hallway in Kenny 6 is at least as long, if not longer, than the length of hallway in the original design.
But it's not dedicated.
I don't understand what you mean by dedicated.
Dedicated
when-
meaning only Gabe is intended to use it, and his siblings can't play in it, leave toys in it. You know, it's a space that's there, you know, solely for the purpose of allowing him access to his home.
If that's how you're defining dedicated, that's not how I would define it, but if that's how you're defining dedicated, then no, this is a common hallway for the entire family so that Gabe can move through the house.
And there's nothing in that design that contributes to preventing the obstructions that the rockers are worried about, right?
Only that it's really a common sense answer, which is when you have a hallway and a passage, there will not be furniture in the spaces that you need to navigate through those things. Can toys be left on the floor? Toys can be left on the floor anywhere, including in a dedicated side hallway. That has to do with the lifestyle of the folks that live there.
But you would agree that it's easier if there's a forbidden area to keep that area clear.
I wouldn't necessarily agree with that, but
Now, in trying to satisfy the needs of the Kennys, there's no place in your design where if the rockers decided that, yes, the dedicated hallway really is important to Gabe's ability to use the property, to use and enjoy his home, that there's no place that can be constructed without interfering with the side yard of the opposite neighbor, right? So
I don't understand the premise of
you
your
put a
question.
driveway and a ramp here, so you can't, on the Kenny side,
Correct.
and a deck, so you can't have a dedicated hallway on the Kenny side,
Correct.
right? And the Brodies live on this side,
And you can't put a dedicated hallway on that side either,
right,
if that's where you were going.
not without intruding into that side yard.
No.
And you have only one egress that's accessible to his wheelchair, right?
There is only one accessible egress.
And how many kids do the Rockers have?
I don't know.
So did you consider the other children in your design?
Not specifically, no.
Okay. I mean, we know at least that they have an infant, right?
No, I know they're a growing family.
And so your design proposes to isolate the parents and Gabe way in the back of the first floor for sleeping arrangements and put all of their kids from infant to, the oldest on the second and/or third floor away from the family.
The home has upstairs bedrooms. The home will have a downstairs bedroom, at least one. As I understand Gabe's needs, as has been entered into the testimony and by the medical, there's a need for close proximity to monitor him while he's sleeping. That would mean a bedroom on the ground floor that isn't in the current design, where the parents would be on the second floor. In a home like this, any family is going to be on multiple floors. Right now, I understand the parents' live or sleeping room is on the third floor. So they're already one floor above, though the stair, I believe, connects directly to what is currently Gabe's room.
Now, do you remember the testimony about seclusion and quiet during day hours?
I do.
And do you remember the testimony that the Rocker children will play in the backyard and come in, and that the front of the house is the quiet part of the house, and that therefore it was better for Gabe to sleep in the front of the house where there's proposed to be a dining room, which would have low use, and the kids would play in the backyard, the kids would play in the living room, the kids would go to the kitchen, and
The
his,
front of the house also has traffic noises and other such things.
you've never been in the house, right?
I've been in the
So you're
neighborhood.
speculating.
I've been in the neighborhood. You know where I've been. An alternative design, like Kenny 6, could have Gabe in a room that is buffered from all of the yard activity by other rooms of the house, so there's no direct windows to the play areas.
So now we're talking about another design, Kenny
No,
Future 8 or something.
Oh, my understanding of your question was to the premise that the front of the house was the best bedroom, or best possible for a bedroom. Without expanding on the ground floor to the rear of the house, there's no alternative than the front. The whole exercise is to explore whether there are reasonable alternatives that can also meet the need.
Now, you testified that this is only the second time you've ever tried to oppose an accommodation for a disabled person.
No, that's not what I said. I said this is only the second time in my career that I've agreed to be an expert for an opposition. I didn't say it had to do with a special needs application.
So the first time it was not a special needs.
It was not.
Now, it seems that you maybe misunderstood the direction of my question when I was asking you about the location of the bedroom. My question was more related specifically to the design that you proposed, and that is, isn't it true that your design doesn't take into account the testimony of Ms. Rockers that she needs the bedroom not to be on the route from the backyard into the house, not to be on a throughway, but to be secluded?
I believe that that there are multiple ways to satisfy the desire for a secluded bedroom. Without a ground floor expansion, the only option that you have is probably to the front. With a ground floor expansion, it opens up other alternatives to achieve those same goals.
But this proposal doesn't achieve that goal.
I believe it does.
Hey, you read the transcripts, and you've been to the Kenny's house. Do you remember the testimony of Mr. Kenny where he said his primary concern with this is that it's going to cut off the sunlight to his dining room?
I don't remember that specifically, but I don't doubt that such a concern exists.
Okay.
I don't remember, for the record, I don't remember reading that in the testimony.
Have you been in his dining room?
I have been in his dining room,
Did you look out the windows?
yes.
What did you see?
Saw landscaping, an adjacent driveway, and the Rocker's home.
So when you say you saw landscaping, I'm going to show you a picture. Does that picture remind you or of what you saw when you were at the Kenny's house?
Yes, the rather large shrub in the foreground is actually adjacent to their living area, which has high glass. There's a slightly smaller shrub beyond, which is in front of their dining room window.
Slightly smaller. But you would agree,
I
this
think it's-
shrub actually obscures the entire first floor.
Well, all I can tell you is that I was able to stand in the dining room and look out the window and see the Rocker's home. I'm 6'4" too.
I think I just need a minute.
Sure. Take a 2-minute recess. As soon as we go, is Chris in it? Here. I don't. You would? Now,
You're not
resume the meeting of the Haverford Township Zoning Hearing Board of Thursday, December 19, 2019. Go ahead, Cole.
So at this time, I don't have additional questions for this witness.
John?
Mr. Shock, I just have two questions. Redirect. We talked a little bit with Mr. Ewald about the front bedroom, rear bedroom that you've proposed, and the differences that might exist with respect to noise, et cetera. Am I correct that the Rocker's design calls for a front door entry beside the proposed bedroom for Gabe?
Yes, my understanding is that in order to convert the current porch area into a bedroom, the existing front door, which enters that porch, would have to be shifted back to the base of the stairs in what is the living room.
So that would be an entrance and exit way for coming and going.
Yes.
And I have one copy of this one. I'm going to show you what's been marked as exhibit NE 10. Bless you.
Didn't think so.
We'll take a look at this before I show it to you. Ask you just quickly, Mr. Chuck, I've shown you what's been marked as exhibit Kenny 10. What does that depict?
That is the view through the window of the Kenny's dining room looking at the Rocker's property. Rocker's property.
John, there's no 8 and 9. So it,
I don't have any other questions for this.
I don't have anything on that.
Yeah,
Questions?
Mr. Chairman, I have a question.
Ed?
The issue, I seen a photograph that came around that the board didn't get to see. I don't know whether that's going to be entered as an exhibit.
I mean, I can if you want. Ultimately, I don't think the light into the Kenny's dining room has any relevance. The standard on the act has nothing to do with the neighbors. I mean, I'm happy to,
If you don't want to enter it, then
Yeah.
don't enter it.
That's your call.
If you don't want to enter it, he's not asking you to enter it.
All right,
It's your discretion.
I put it into my, it'll take me 5 minutes to find it, so.
Any other questions?
Yeah, okay, so we can, I don't know what this would be. I think it's applicant 18.
Hold on. I don't think 17 ever went in.
Actually, I do have a question, if that's okay.
Yes.
That photograph that you just testified about, do you know when it was taken?
I don't.
Did you take it?
I did not.
Okay. Only have a couple of copies, I'm sorry.
Okay.
I don't have any other questions.
Has that been marked as, oh, wait, for
A18.
Mr.
I guess I'm not excused yet.
Well, just very quickly, they marked as an exhibit A18, and Mr. Ewald had asked you regarding Kenny 10, whether you knew who took it or when it was taken. I'd ask you the same question with respect to what's been marked as A17 or A18.
18.
Do you know who took that picture or when it was taken?
I do not to either of those questions.
Thank you.
All right, wait a minute. Shot. Questions?
Can I get a description of what that is? A18?
Mr. Ewald introduced it. I don't know if he wants to put anything on the record about that.
Would you describe it to me, please?
It's a photograph taken from the street of the Kenny's side of their property that is facing the Rocker's house. And it shows very large evergreen shrubs that obstruct the first floor of that house.
Bill, do you have any questions for Mr. Schock? I do not. Kenny?
No.
Ed?
No.
Jessica?
No.
Okay, neither do I. Thank you.
Thank you.
I would call Mr. Greg Roxon.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and the capacity in which you are here for the board, please?
My name is Greg Rotzel, and I give one background.
Well, I'll do Bart.
Okay. Rotzell.
Go ahead, John.
Mr. Rotswell, what is the nature of your profession?
Contractor.
And why don't you give the board a little bit of background on your work history in the field of construction and your present occupation?
Okay. I had the opportunity when I was in high school and college to work for a contractor upstate building new homes. And after I graduated from college, I got a job as a project supervisor at a company, Paul Brothers Builders. I was employed there from 1973 to 1982. Then I went with the company from 1982 to 1996 as a project supervisor and estimator for a company, Bro Rock Builders in Berwyn. Bro Rock, capital B-R-O, capital R-O-C-K. Then another gentleman and myself formed our own company in 1996. I was the president of Home Insured Services Incorporated, and I did sales and estimating till 2016, where I turned the company over to the gentleman I was in business with, and now I work part-time as, from 2016 to present, as estimating, and I do a lot of appraisal work for insurance companies. All the companies I've been involved in, we've done additions, renovations, home renovations to properties, and we do a lot of, did insurance work. We do insurance work, which is fire restoration, water damage, hail, windstorm damage, repair work. So we've done all three. I've done all those three facets since I got in the business in 1973. So that's kind of my background.
So, Mr. Rotzel, I'm going to focus independently on two different areas. One is your activities on construction work, and number two will be your estimating work. So if I can begin with construction work, what sort of construction work have you done in your career beginning in 1973 forward?
Well, before I framed houses, I was on framing crews when I was in high school and college when I had the opportunity. With the other companies, in 1997, project supervisor, I was supervising and hands-on from 1973 to 1982. 1982 to present, I was more supervising and estimating. I wasn't really doing work hands-on.
And was any part of that construction work that you did residential construction work?
Yes, it was, our work is about 80% residential and about 20% commercial work.
And was any of that residential work single-family residential work?
Yes.
And so when you talk about doing estimating work, what does that involve?
Well, estimating, well, it all depends what project it is. You know, you have home renovations, you have additions, which we're facing tonight, and then the insurance restoration, you're rebuilding properties that have been damaged by storms.
And is there some common element to all of estimating in the sense of when you come up with an estimate for work, is there a process or a common process involved?
Well, it's basically a lot of square footage pricing, a lot of lineal footage pricing, and then there's areas and trades that you do labor and material. The square footage or lineal foot doesn't really come into play.
And what makes you good, if you or consider yourself good at doing estimating?
I've done it for so long, and I've seen a lot of different structures, older homes, newer homes, and all over, you know, the Tri-County area. Just the experience of doing the renovation work.
And do you have experience taking plans and from plans, doing estimates and cost estimates?
Yes,
Is that something you do frequently?
yes.
Members of the board, I would like to offer Mr. Rotzel as an expert in construction and the estimating of construction costs.
I just have a couple of questions. You tested, or you talked about your history. What are you doing now?
I'm part-time estimator, and I do appraisals for insurance companies around the Tri-County area and sometimes travel in Pennsylvania.
And your
So,
clients are?
It's like 3 days a week instead of 5 days a week.
And your clients are who?
Our clients?
Yeah.
Well, they're homeowners that want renovations or additions done, and we're dealing with homeowners that have been affected by, you know, an insurance claim.
Okay.
So
So you
there's-
don't represent the insurance companies, you represent the homeowners?
Yes,
Okay. And when you're representing a homeowner who's asking you for an estimate, they're conceptually thinking about an addition, and you're trying to give them an idea of how much it would cost, but you're not quoting it for them, right?
it's larger losses that people will, if they have damage to their house. This is an insurance claim, not an addition or a renovation, which is separately. An insurance claim, a larger loss, yes, they will take advantage of putting an addition on the house, adding on somewhat to what they've been thinking about, but, you know, didn't do it. Now they take the opportunity to do it. That's just the insurance side, not the private side.
So are you still doing private?
Yeah, oh yeah.
And So that's what I was trying to understand. What do people who hire you for? You're not going to quote them a price, you're going to give them a range that they should look for?
Our procedure, if the rockers came to our company, Home Insured Services, if they came and they said, this is what our procedure is, what my procedure is, they got my name and they wanted a price for an addition, I meet with the people, okay? They usually have plans that are drawn up as they had, and I meet with them and I give them see what they have, give them a ballpark figure. Builders that I talk to, deal with, and in a standard range is $150 a square foot, just to give the people an idea of what they're thinking about spending. Some people will say, I don't know if I can do that right now. Other ones say, I'm very serious, I want to do it. At that point, stage two, what I do, I come back, I bring my engineer, because usually there's some engineering issues that the architect doesn't pick up. And if I have to meet with the architect, I will have them there, the people that got the architect, and I will meet with the people and start hashing out, okay, it all depends what addition you're doing, what flooring do you want, what cabinets, what tops, so that's kind of stage two. That's what I usually do. That way, I can get all the material and give a pretty well detailed estimate of what it's going to cost them.
And then do you do the work?
Oh, yeah. Home Insured Services is a construction company.
Okay.
So we do estimating, appraisal work, and we do the restoration, and we do additions, and we do some home renovations, but more additions and restoration work, yes.
Okay. So you do estimates for what it would cost for you to do the work?
Yes.
Okay. I think he can testify as to what it would cost for him to do the work.
And sir, have you ever been censured or subject to any disciplinary action from any licensing authorities?
No. Excuse me, no.
And John, what are you offering him as an expert?
An expert in construction and the estimating of construction costs.
We'll accept him as an expert in that area. Please proceed.
Mr. Razzo, first of all, where do you live?
In the Oakmont section of Haverford Town?
You're familiar with Havertown in general?
Yes.
How long have you lived in the area?
Since we graduated in 1974, 3. We had an apartment, my wife and I, and then we moved in the house, which we're still in, since 1976. So.
And so as I did with Mr. Schock, I'm just going to ask you some questions about what you may have done to acquaint yourself with matters that are relevant to this proceeding. Have you visited the place where the Rocker's house is located?
Yes.
You've not been in the Rocker's house, is that correct?
No, I have not.
But have you seen the Rocker's house?
Yes, I have.
And have you been to the Kenny's house?
Yes.
And have you been inside the Kenny's house?
Yes, I have.
There has been submitted into evidence by the applicant what's been marked as A1 through A10, and I think also collectively marked as A13, which are plans of Mr. Poynton that reflect a design proposal for the Rockers addition. Have you seen that?
Yes, I have.
All right. And have you also seen what's been marked as Kenny 5 and Kenny 6, which were the plans that were prepared by Mr. Schock?
Yes, I have seen them.
And have you also seen what's been marked as Kenny 7, which was a 4-page document that reflected an alternative design superimposed on the design that was prepared by the Rocker's architect?
Yes.
Were you also here at the last hearing at which there was testimony given regarding the potential construction costs for the design proposals that are at issue in this proceeding?
Yes.
So you were here for that whole hearing, correct?
Yes.
I'm going to start out with a very general question, Mr. Rotzel, and then I'll get into some of the detail on it. But as a very general matter, based on your professional experience, and given the size and scope of the three designs you've taken a look at, which would be the Rockers design, the shock design, and the design that's reflected in Kenny 7, do you have any belief that they all should cost about the same?
I can't really testify because I didn't, on the shock design, because I haven't looked at that. I just got that, a little bit ago, a couple days ago. But with the overlay design that I got from the Kennys, the Mr. Deeming design and Mr. Poynton's design, to me, they're coming out very similar in cost, yes.
Here, let me, show you what I've marked as Kenny 8. Mr. Rosso, I gave you what I've marked as Kenny 8, and just for the record, it's a single page, and at the top, there's the wording Home Insured Services, Inc. And could you just, as a general matter, identify that for the board?
This is, I was asked to give on both editions, the side edition, the rear edition, I was asked to give estimates for budgeting estimates. So I tried to pull everything together. The procedure I do, I kind of sketch everything out, and I think it would be advantageous if I can tell then the board what I figured for. But these are budgeting figures, and they also include, we usually figure 15 to 20% profit. That is included in these figures. So the zoning board knows that.
Well, let's slow down just a little bit,
Okay.
Mr. Rotzo, and say, first of all, am I correct that what's been marked as Kenny 8 represents your estimate of the construction work that you see indicated on what's been marked as Rockers 10?
Yes.
And so what was your process in developing this costing estimate?
Okay. In Mr. and Mrs. Rocker's estimate, going by Mr. Poynton's layout, what I figured for was some renovations to the front office area, the front entrance porch, which is almost a 9 by 10 area, a 2-story side addition, which is approximately 552 square feet. Then the bump out section in the back of the property that is existing, you have a little 6 by 10 area, 1-story that you're continuing with the 2-story addition. And then you come over to the bump out section that's existing. Then you're filling in another 6 by 10 area to the left rear of the property. And I don't know if, and that shows, I don't know if everybody has the point that shows on Exhibit A2, the Poynton's with architect, which is showing all the kind of crisscross line shaded area. To me, I took it, that's what all was new addition, and the back rear section there to the left, the white area there on A2 in the back is existing. I figured also for the renovated bathroom, the renovated kitchen, the excavation of the old driveway and landscaping work, curbing work, sidewalk work, which will all entail because you're taking out the old driveway and you're moving it over to the left side of the house. So you have landscaping, sidewalk work, curbing work, and you're doing all the excavation for a new driveway on the left side of the house with sidewalk work, apron work involved, putting the new driveway in. And then there's a smaller, he has a 40 square foot ADA ramp in the back, which you need access in then to get into that little addition and to get in the door. So that is all the areas that I sketched out and figured what had to be done to come up with the side addition trade budget list.
And as you did that, I think you mentioned already, did you account for the moving of the driveway?
Yes, I did.
And did you account for a ramp and a lift?
Yes.
And could you talk to us a little bit about the consideration of inside walls in this particular proposal that's
Yes,
reflected?
well, you'll see when you get the rear addition, they're very similar, but the rear addition layout, you don't have as many, you hardly have any interior walls versus the side addition.
You say rear addition, are you talking about what was marked as Kenny 7?
I guess. I don't have the mark, I don't have Kenny 7, 8, whatever. I have you'll have to show me. This is the one I have. Yes.
I just wanted to make that clear for the record.
What is it, Kenny
7.
7?
So you're shorthand for that
Yeah.
rear addition. And
So what you see when you add more interior walls, naturally you have more studding of the walls, you have more drywall, you have more painting, you have more trim. So even though you just have more lineal feet of items and square feet of items when you're adding interior walls versus more open area.
let me stop you there and show you what you marked as Kenny 9.
Okay.
So you have in front of you, Mr. Rotzo, what's
Yes.
been marked as Kenny 9. That's a one-page document. Again, it has home insured services at the top, and below that, beneath the letterhead, there's language that says rear addition trade budget list. You see that?
Yes.
Okay, and so what is Kenny 9 for the edification of the board?
Kenny 9 is, how I figured for the rear addition trade budget. Also, on that estimate was office renovations. There was entry steps and landing coming in the front.
Well, without getting into all the specifics, which we'll
Okay.
perhaps discuss, as a general matter, this represents your cost estimating
Yes.
for the cost of construction of what's reflected in Kenny 7. Is
Ye-
that fair to say?
Yes.
And so, in terms of your process for doing
Okay.
an estimate, was it similar to the process you've described with respect to the costing of the Rockers addition?
Yes. The areas where some renovations to the front office area. There is a entry steps and landing. I was given 55 square feet. There's an ADA toilet room, renovated kitchen, renovated bathroom, a 264 square foot deck, a 130 square foot patio, the two-story addition in the rear. The first floor was 225 square feet. The second floor was 308 square feet. There was an ADA ramp on the right side of the property. And then I added an addendum because I was approached to add what a one-story side addition would be like a foyer and hallway, and that was 5 by 22, 110 square feet.
That foyer hall and hallway are the one-story side addition within the side yard setback?
Yes.
That is reflected on Exhibit Kenny 7, correct?
Yes.
And so, could you talk a little bit for the board about your ultimate calculation of the relative cost between the design that's reflected in the Rockers proposal and the design, let's say, that would be reflected in Kenny 7?
Like you can see there, the Rockers edition is a couple thousand more if you add the side to the other one than the rear edition, if you have those two, the trade budget list.
And so if you talked about the addition that's proposed by the Rockers, that number was $168,578, and the proposal that was, rather the estimate that was done for the rear addition that's reflected in Kenny 7 would be something on the order of $164,000. Is that fair to say?
That's correct.
So can you talk to the board about, just as a general concept, why it is that these would be relatively similar in cost, these two different designs?
Well, even though there's different facets of each edition, some are similar, some are different. Square footage wise, they're close. Square footage wise of just the addition parts, they're real close.
And we also talk about rehab right within the house.
Yes,
And is there equivalency there too as well?
yes.
So you were in attendance and have heard that the Rockers have discussed a proposal for the construction of the plan that is proposed in Exhibits A1 through A10 of about $105,000. First of all, is there, in the estimate that was prepared to support that $105,000 estimate, are there things that are not in there that are in your estimate?
I think the exterior work,
That's the driveway?
yes, both driveways, the landscaping work, anything exterior, the sidewalk, curbing, apron work. I don't know if I don't think the ramp in the left rear was in there also. But everything else, I think, was in that proposal.
So, given that, and even with the elements that were missing from the $105,000 estimate, are you able to understand how that $105,000 estimate could be proposed?
I just have, the one concern I have is that, yeah, there's different facets of each and work, but square footage wise and what's going on with both additions, I would think they would, in my experience, would be fairly similar.
And so if an addition that was built consistent with the Rockers plan could be built for something on the order of $105,000, would you think that given the scope and the nature of the work, that the same cost could be applied to the work that's reflected in Kenny 7?
I'm not sure what,
Well, from a square, let's
Oh,
talk
square
about
footage.
Square footage
Yes.
consideration. So if there is, let's say it's $125 a square foot for the addition that's reflected in the Rockers plans, if you use that as your baseline, $125 a square foot, would the design that's reflected in Kenny 7 come out about the same?
Yes. I use 150, but I don't, as a $150 a square foot to give people an idea what it might cost for an addition. But I don't, when I estimate, I don't just say it's 150. I go very detailed, you
And
know,
so-
all the different trades and everything that's being done. I don't do per square foot the whole addition.
Do you recall from the testimony last time that the contractor talking about doing the work that's depicted in Kenny 7, or its predecessor, which was Kenny 3, indicated that he estimated based on about 1,000 square feet of renovation work?
I think he had living space. I don't know how that, 1,000 square feet, the proposed additions, just the addition work was like 612 or 640 square feet of the additions that were being built. But there are renovation work within other areas of the house and expanding.
And so would that be, I'm going to leave that.
Yeah.
Now, recognizing that you may not have fully costed out what was reflected in the design by Mr. Schock that's reflected in Kenny 5 and 6, did you have an opportunity to at least look at it and evaluate it on a relative general scale?
I looked at it, but I didn't have a lot of time to do any costing or anything like that. All these three additions it takes time to give a fairly accurate number.
Do you have any commentary for the board about the complexity relatively of the work that would be proposed in the Rocker design versus the work that would be proposed in the Schock design? That is the difference between the side addition with also some rear work, with also
Yeah.
some front work versus Mr. Schock's design that was a rear-only addition.
Well, it would definitely be more of a disturbance doing the side addition and then adding the rear than just doing the rear. And it's easier because it's only one story. I would have to take, with his square footage, the deck, working in the bathroom, working in the kitchen, all that, it's hard to say. It would probably be very similar to the other two, but I can't be exact on that.
Board, please, could I just take 1 minute? I may not have any other questions for Mr. Rossi.
Sure.
Thank you, Mr. Rossi. I don't have any other questions for you. Mr. Ewald, the board.
I have a few questions.
Okay.
So, when you evaluated the Kenny's plan versus the Rockers plan, you didn't include moving the driveway in the Kenny's plan.
There is no moving the driveway.
Who decided that?
Shows you in the plan.
Okay. So you didn't do any independent analysis of the ordinances or the law to determine if the driveway could be moved
No.
or had needed to be moved? So,
That is usually done by the architect, and I usually get an engineer in there because you're going to eventually have to get all these plans done in order to take a permit out through the township. But usually the architect, no matter which addition you're doing, usually spells all that out. That's not my job as a builder. At least
So-
that's from my experience with doing other projects.
so you took the word of the architect who designed Kenny 7, or you didn't even talk, did you even talk to the architect? Did you ask him if that,
Which
about it?
architect,
Well, the one who designed Kenny 7.
which,
That's the one that you
give me
estimated.
the side or rear.
That's the rear with a option for a side hallway.
Yes, I did talk to Mr. Deeming, talked to him about what he was proposing, yes.
Did you talk to him about the driveway?
No,
Okay. So if I were to tell you that parking spaces in the township of Haverford are required to be 9 foot wide, and with that hallway, there's insufficient space to have a driveway with a parking space on the side, would that influence your costs?
I was asked to do, I wasn't asked to do any driveway work. I was asked to do propose something for the side 5 by 22 addition on the
Okay.
side.
But you included the cost of moving the driveway in the Rockers proposal.
Well, you had to move the driveway because you were putting a 10 by 27 and a half side addition on, how can you keep the driveway there? And it was in Mr. Poynton's plans.
But you didn't evaluate whether the driveway would have to be moved in Kenny 7. You just assumed
No.
it doesn't.
No, it wasn't in any plans to move.
Okay.
When you were doing the side addition for Mr. and Mrs. Rocker, you had to move the driveway over to the left side. Now, when you're doing this, I didn't take any of that into account.
Okay. And so if, in fact, the driveway would have to be moved in either instance, then that's going to drive up the cost of the estimate you did for the primarily rear.
Yes, yes.
Okay. And the design that we saw today, I think it's Kenny 5 and 6, that was just dropped on you 48 hours ago, and it was
No,
insufficient
it
time?
was, it was emailed me a couple days ago, yeah.
Okay.
I don't-
And that's not sufficient time to
No.
prepare for a hearing?
No.
Okay. And are you aware of, so you've never been in the Rocker property, right?
No,
Do you know where the plumbing is,
yes.
plumbing stack?
Well, I know where it was in the Kenny's property, yes,
Okay.
and the
So
electrical.
do you know where it is in the Rockers property?
No. I was
Okay.
told the houses were identical,
Told by who?
except Mr. Kenny. They were identical, except naturally, Mr. and Mrs. Kenny have a two-story addition on the back of their house, which the Rockers don't.
And do you know did you evaluate the electric in the Rockers house?
Yeah, no, not the Rockers.
Okay.
But I figured, in both estimates, I figured both new 200 amp services, plus all the other, rewiring, switches, outlets, rough wiring, everything, lights, smoke detectors, carbon monoxide detectors, everything's in the electrical bids.
So if I were to tell you that the placement by the architect, which I understand is not your, decision or,
No.
of the ADA bathroom in that former front office, soon-to-be bedroom, if it would be approved, that's on a slab. Does that
Yep.
change your estimate as to the cost of the
No,
plumbing?
I figured you're going to have to come through the front foundation part of the house. I figured for putting sleepers on that area, in that office area in the front that they have, sleeping the floors, and then naturally covering with plywood, floor finishings. But the plumbing, the water lines would not be that much of a problem. But I agree with Mr. Papa from his testimony last time, the drain lines you would have to cut into that concrete slab work.
And that's not factored into your estimate?
Yes, it is factored in there.
Okay. Now, you were just asked about K5 and K6, the new plans that were provided by Mr. Schock. And you said that you thought the cost would be similar to the other two. When you say similar to the other two, does that mean your bids, or I'm sorry, your estimates that were just provided marked as K8 and K9? Is that the other two that you meant?
Yes, yes.
Okay. Just, you think that the Schock proposal would be somewhere in the realm from $163,799 to $168,578?
I would think so, but I can't be exact. I have to estimate. I would look at the factors. You're saying the one plan had 692, but you're given 800 square feet or so now, okay, of new one-story addition. You have to factor in the bathroom work that you're doing, all the plumbing, fixtures, and everything into that bathroom. And then you got to figure the kitchen, doing all the kitchen work in there, all the plumbing, all the cabinets, tops, and everything. And then you got to figure in the ramp, whatever size that was, and you got to figure in the deck, the new deck. And then you got to figure in removing the existing deck and patio. So
it may be more than,
well, I'm just saying, I can't just throw a number out, okay? That wouldn't be fair.
Okay.
I don't operate that way.
now, when you compared the foundations, why is the quote for the Rockers version, the side version, almost $3,000 more than the Kennys, when the Kennys have at least 15 feet more of linear?
They don't have 15 feet more of it's actually, if you're doing a 10 by 27 and a half on the side, and then you got coming 10, 27 and a half, and 10, then you're extending where the one-story bump out is on the side. You got to extend that 6 by 10 area 1 story in the back. And I can show you, and then you got the 6 by 10 area over to the left side where the driveway's going in the ramp.
Are you saying the proposed addition on the Kenny's drawing, the bedroom on the second floor doesn't go past the existing first floor of the current building?
Here's where, well, this is here, okay? So this bump out section is already here. There's a 6 by 10 bump out. So you're coming up 8 over 22 and down 14. That's the first floor, okay? Because you have this 6 by 10 already bump out area. I had, hold on. I had I had them about 76 lineal feet versus maybe 82 lineal feet for the rockers, somewhere around there. It was very hard to work off of both plans. I usually have more, when I work off plans, and I don't know what Mr. Papa would say, but when I work out plans, they're more detailed and spelled out on both sets of plans. They really are. I'm given more accurate measurements, I would say, by an architect when they do play. Normally, yes. So it's a lot of, okay, trying to measure and figuring out what they were doing and everything.
Now, you were here when you heard Mr. Papa testify, and he did a drywall analysis, and he found that basically each drawing takes about 65 sheets of drywall. Did you hear that testimony?
No, I didn't recollect that.
Did you do that analysis?
Well, I do everything square footage of rooms. So you have to have more drywall square footage in the rockers estimate versus the other estimate, because there's more partition walls on the first and second floor. If you see,
Because you don't include the hallway in yours.
no, I did, but there's no partition, it's all exterior walls. It's a foyer and hallway. When you're doing the first floor, you have all these interior walls. Second floor, you have all these interior walls. When you're doing the rear addition, there's very few interior walls. They're all exterior walls. And I figured 2x6 exterior walls with insulation and 2x4 interior walls, because most people want the added insulation now, the 2x6 exterior walls. So there's definitely more wall footage, square footage, when you're putting up interior walls.
Is there a difference between an estimate and a bid?
I don't really do bids that much. Mine are pretty detailed estimates, whether I'm doing renovation work, additions, or insurance work. It's more of a detailed estimate, not bid, no.
Okay. So if the rockers have a bid for $105,000 and $105,500,
Yes.
they should take that, huh?
I'm not critical. The way builders have a bad name to begin with, I don't criticize any builders that I work with or any other builders that I see bids, but I have a hard time. I could not do the amount of work that I mentioned, less taking out all the driveway and outside work. I could not do that work for $105,000.
That's what it
That's
was
for
to
me.
hire you.
Yeah, yes.
I don't have any other questions.
Good.
So, Mr. Rotzko, if somebody can do the rockers work for $125 a square foot, given the relative complexity of the two designs, should somebody be able to do the shock design for $125 a square foot in terms of the relative complexity?
Yeah,
Yes.
I would object. He's already testified that he hasn't had enough time to evaluate the shock plan. You know, this is speculative and not evidence.
I think you gave an answer yet.
So my feeling was it was speculative.
Not in terms of the relative complexity and scope, which is how I preface my question.
I'd recommend you let it.
I don't have any other questions after that.
All right. Do you have anything else, Carl?
Not for this witness.
Questions from the board? Jess?
I just wanted to ask whether your estimate for the side addition included reconfiguring the second floor stair?
No, it didn't. That's one of my concerns. That's the only concern I really had on that plan, was having enough headroom. The way the staircase, it's an L shape, you come up, come to a landing, up another set of steps, you're into that second floor hall. And there again, that would be my question if I met with the architect that designed it and had my engineer there at the same time. Because I never could figure out on this Exhibit A5 of the Poynton plan, he has reconfigured stair to attic corridor. I have no idea what he says open to below. That I question and it bothers me. But, that's just, I don't like criticizing, but I had a question about having enough headroom by adding a second floor to the side there. That's all.
Okay, thank you.
Welcome.
Andy?
No questions.
Any?
No.
No? Okay, thank you.
Thank you.
Go ahead, John.
I have no further witnesses to call. I would just offer into evidence what I have to mark Kenny 1 through Kenny 10.
I mean, my objections continue to shoehorning in of testimony of someone who has agreed not to testify, but you've already overruled me on that, so.
Right, there was no agreement on the record regarding. Here's Kenny 7.
Mark more than.
Yeah, so the agreement that was claimed, we don't have, that was not done here in front of the board, so that was the basis for
I mean, he did it.
allowing.
You used all sorts of qualifying language.
Yeah, well.
So there is or there isn't an agreement, whether it was or wasn't agreed to.
If it will make the Rockers more comfortable, my clients will agree that having met the Rockers, Mr. Deeming will not appear as a witness. Oh, I'm sorry.
Arlene's great, but
If it will make the Rockers more comfortable, my clients will agree that having met with the Rockers, Mr. Deeming will not appear as a witness against. It was a condition of.
I mean, I understand your point, but not here, so. I recommend you allow it, so.
they're admitted. Anything else?
Nothing.
Greg? Anything?
Yeah, I mean, we've been going for 3 hours. Can I just take a 3-minute break?
Yeah, sure.
And then I would like to recall Ms. Rockers just to address some of the things brought up.
Okay. We have tonight 25 minutes left before we are required to end.
I think it will take me 10 minutes.
I'm not trying to rush you. I'm just.
Yeah.
Chris in there. Now we're back on the record. Mr. Rhodes was kind enough to bring to my attention, there are now 2 exhibits marked A18. One was the memorandum of law from DOJ,
Okay.
and now this photo of the Rockers home.
Let's make that one A19.
It'll be official. All right, go ahead, Carl.
All right. The first first thing I'd like to do before I call Ms. Rockers is I'd like to request that the board take judicial notice of its own minutes from 2019. And I could ask to call up your secretary and have her testify as to the authenticity, but I think this board can accept and admit its own minutes as a record of zoning history. Specifically, I have the minutes from, I'm sorry, I'm missing one. January, February, April.
I would object to the introduction.
And October. He has an objection.
I would object to any introduction of minutes for other proceedings or related to other matters, and which transpired during a time when the Kennys weren't present and I wasn't present. It's not part of the record, and it shouldn't be part of the record in this proceeding. I think what should be before the board is the evidence that's been presented at the 4 hearings that the board's conducted with all parties present.
Well, that's, yeah, that's what it is, so we'll see all for proof.
So this has a record of the decisions that this board has made in 2019 regarding requests for variances into setbacks. And one of the key issues before the board is whether the requested accommodation would undermine the zoning code. These records, the records of your body, voted and approved on by you, clearly are admissible, and they show, or they tend to show, that granting of a intrusion into a setback where the facts allow it, or where the facts support it, is not undermining the zoning code.
I mean, I think it's relevant to the question at hand. I think that is a relevant question based on what I've researched, so I think they should let him in.
What we don't have is any of the record as to these proceedings. So, what the applicant looks to do is to bootstrap its application with summary information regarding other applications in which I didn't participate, the Kennys didn't participate, and the particular facts of which are not articulated in a record, but just appear in what are characterized as minutes. I think that's grossly unfair to the applicant to somehow have proceedings in which not the applicant, the Kennys, to have material relating to proceedings in which they didn't participate and which they are hard-pressed to be able to discern what any of the detail was in these applications. I mean, these applications stand on their own with testimony from witnesses, perhaps cross-examination, there may be distinguishing factors, there may be an absence of any objection and perhaps stipulation. Look, the board knows what its history is, the board knows what it's done, the board is going to bring that knowledge and information to its consideration of this application. But to introduce these minutes as evidence, as somehow tending to establish one way or the other facts in favor of a result, I think is inappropriate.
To be clear, I never said that any of these decisions have a precedential value on this case. It's just showing what's happened this year and whenever there's been a question about a setback.
Do you have a sense of how many of the cases that you've had here involved opposition on the record or party status granted to anyone other than the applicant?
I don't have any sense of that. And if the board would prefer, I can ask that they take judicial notice of their actual opinions, which would be, more cumbersome. But I don't know that it matters, whether someone opposes or doesn't oppose. It doesn't have any factual value on a zoning application. It may have practical value or impact, but it's not relevant to the test for whether a variance should be granted.
What's the purpose of entering this into evidence? Because we do know our decisions.
Well, because this will go up on appeal, is what we've been told by the other side. If we prevail, it's going to go up on appeal. So we have to put these things into the record.
We haven't made any decision on that, and we don't know what this board's going to do.
My question is, the facts and circumstances surrounding every case are unique. The facts and circumstances surrounding this case are unique. What relationship between prior decisions and this case, what are we to infer from it?
So the only inference that I'm asking you to make is that when the facts, the peculiar facts of each individual case, when the facts in a case for a setback merit the granting of the setback, it's been approved. And that has not undermined the zoning code.
Think about what you're being asked to do here. So you're being asked in the first instance to throw out all variance considerations, because this is a variance case according to the applicant, it's an FHA case. But as you consider whether this FHA case should be decided in one fashion or another, we're going to reel back in variance-based cases and use those as support. So on the one hand, we're looking at cases that were decided purely under the variance standard. And in this case, which obviously doesn't meet the variance standard, and where you're being urged to use the FHA standard, you're being asked to use variance cases to support that. I mean, recognizing that each case stands on its own, it's even more extreme in this circumstance, because we're talking about, as the applicant wants you to accept, two different standards of proof. None of these cases, I wager, related to somebody coming before the board and asking on the basis of FHA law for a relaxation of the ordinance.
But they are intertwined. I mean, they are intertwined.
How do you mean?
The FHA and zoning
I think the applicant,
policies and how they're implemented are intertwined.
I think the applicant's position is you're not looking at a physical hardship that's related by a condition on the land. You know, one of the fundamental elements of a variance, that you don't need to take a look at that because this is FHA, that you don't need to look at whether the property can be otherwise used for a lawful purpose, because that's a variance standard, but it's not applicable under the FHA. So I don't know where the intertwining comes, other than to the extent that you look at a variance and look for necessity at some level, and then you see that there's an element of necessity in the FHA. But on a more fundamental basis, you know, if the variance standard won't work here, and it's the FHA standard that has to apply, then all these minutes of all these cases that were decided on a variance standard have nothing to do with this case.
Under Lapid Laurel LLC v. Zoning Board of Adjustment of the Township of Scotch Plains. I'm sorry. Lapid Laurel LLC v. Zoning Board of Adjustment of the Township of Scotch Plains. One of the factors that you're required to evaluate is whether requiring whether the accommodation requested requires a fundamental alteration in the nature of the zoning program. If you have the ability under whatever program, under whatever theory, to evaluate the facts as related to a property and then apply those facts to grant a relief from a setback, then that tends to show, and you can give it whatever weight you want, but that tends to show that granting a setback where facts warrant it doesn't undermine the zoning code.
And I won't say anything more at this because we're killing it, but I come back to this thought that each case has to stand on its own. And the question of whether something might impact more generally the zoning ordinance is tied up in what's involved in that particular case. You know, the case that's before the board, the facts that are before the board, the implication and the effects that are before the board are what the board needs to consider. And the fact that in 5 or 6 or 7 or however many other cases, maybe there was a judgment made that there wouldn't be a negative effect, doesn't mean in this instance there isn't. I don't think it tends to prove it one way or the other. Different is different. And if other cases are different than this case, it doesn't tell you anything about how you should view and perhaps decide this case. I'll be repeating myself.
I
Let's
agree.
make a decision.
If there's any discussion or opposing viewpoints from my fellow board members, I'm willing to listen to them, but I agree, and I would not admit them. Any comments?
Yeah, I agree. I think our opinions on the other cases stand on their own, and that they're not probative of this case at all, so I don't really see why they're relevant.
Okay, let's move on.
Those two didn't even have the same. I don't even know why they're here.
Carl, I'm going to go out of order real quick. There's a few neighbors here that want to talk, and we have limited time.
Right.
Right, please come forward. I'm going to ask if there's anyone present that received or certified mail that wishes to testify, please come forward. Did you receive certified mail?
It was not certified, it was general mail.
Okay. Anybody receive certified mail? Regular mail? Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and address for the record.
Edward J. Donnelly, 2016 Oakmont Avenue, Havertown, PA.
What would you like to tell us, Edward?
Thank you for the opportunity to offer some testimony to this situation. My wife Cheryl and I are 30-year residents of Oakmont Avenue, the past 23 years in our current residence of 2016, which is across the street and 2 doors down from the applicants. We have a vested interest in the decision of this board, as it will impact our neighborhood and the potential flow of traffic on our street. I feel compelled to state that the communication on the part of the applicants to the neighbors immediately impacted and those surrounding has been minimal, which has resulted in the financial outlay on the part of the Kennys to assist the applicants to meet their needs. Having understood the testimony of the architects and other subject matter experts, the alternatives which minimize the impact of everyone involved must be considered. Listening to the line of questioning, In listening to the line of questioning regarding the house with the proposed hallway and the allocated space, having raised 4 children in my current house, I can state unequivocally that it is essentially the same layout and configuration of the applicants, and there will never be enough space in these homes without continual reallocation of space. And the factor that no one can articulate is that the children get bigger and more active. The houses can only be enlarged so much, and despite our best parenting skills in our current property, with the aforementioned factors of size and activity, there is very little space to be considered as dedicated. The argument to not move the necessary expansion into the backyard to accommodate children playing in that space is, in my experienced opinion, having raised 4 children, is a very short-lived one. In this community, the children, as they get older, spend less time outdoors in their own yards as activities demand them to be elsewhere. For example, the gyms, the school, ball fields, etc. I recall my neighbors who moved in right next door to me while their children were very small, commenting that all they saw was our car backing out of our driveway and pulling back in because we were shuffling our children to their necessary activities, and they are now where we were when they moved in. My youngest child is 21 years old. My oldest is 28. I request that the zoning board give serious consideration to the options and the testimony offered by and paid for by the Kennys, as they, along with the Brodys, who have a young family of their own, are the most impacted by the applicant's architect's proposal and are vested members of our community. In summary, I feel it is warranted to consider the overall limitations of the property boundaries relative to the needs of the applicants and their desires, and that this is the wrong house for their stated needs and desires with respect to the negative impact to their neighbors. Thank you for the opportunity for me to offer my testimony.
Good. Thank you, Edward. Any questions?
I have a question. You say this is the wrong house. Are you suggesting the Rockers should move?
I'm not suggesting the Rockers should move. I said, given the desires of what they have requested, the boundaries of the property can only expand so much. That's all I'm saying.
And you said that the Rockers haven't reached out to you enough. Have you reached out to the Rockers?
I have reached out to the Rockers. I came to their property and sat on their back porch and asked for information.
And did they give you information?
They gave me information at a high level, yes.
And were they friendly?
Very friendly, yeah.
Yeah.
But I will state in the 3 years that the Rockers have lived in our neighborhood, and the 23 years that I've lived on the street, I've met Gabriel once. And that was when he was in this room.
Right.
Is that it, Carl? John?
That's it.
Thank you for the
Do you have any
opportunity.
John?
No, he's not a witness.
Board members? Yeah, he's sworn. So, board? No?
Anybody else?
Nope. Okay. Anybody else ever see regular mail? Any other residents of Haverford Township?
He's a neighbor though, so
Please raise your right hand. Do you swear to tell the truth, nothing but the truth, so help you God?
I do.
And your full name and address for the record, please?
My name is Philip Reno. I live at 1812 Belvedere Avenue, which is 1 block over and a half a block down from the Rockers property.
What would you like to tell us, Philip?
I'm acquainted with the Rockers. I've moved into the neighborhood at about the same time that they have. I know them better because our eldest daughters have become good friends. And our experiences and experience of thinking of their daughters, or my daughters, is that they've had a really good experience in after having moved here in this township and also in school. And the one thing that I've seen that has been really impressed me about the school is how the school incorporates people of different abilities into the classroom, sometimes with a lot of assistance. The only way people of different abilities can participate in our community if they're allowed to live here. And I'm concerned that this standards being requested upon them to try to find a reasonable accommodation that makes Gabe's ability to live here, along with their family. I don't know what the intent of the complaint, but it effectively would, given the older housing stock, produce a red line of which people of certain abilities would not be allowed to live here in this community. And that such exclusionary attempt or effect of the policies would be very detrimental to us all.
Question? Carl?
No, thank you.
Don? Board?
No.
Okay, thank you. Anyone else?
my name
Please raise your right hand. Do you swear to
My
tell the
right
truth,
hand,
all truth, and nothing but the truth, so help you God?
I do.
And your full name and address for the
My name is Alicia with an E, Alicia Mancini Dewar. I live at Elysia. Last name you can use Durr, Durr. I live at 136 Juniper Road in Havertown. I'm also an attorney for Disability Rights PA, although I'm just here as a neighbor right now because we don't have this case yet. I'm a little bit disgusted with this case. I'm disgusted from the moment I came in the building. It's a brand-new building. There's no button on the door for people who are in a wheelchair to gain access independently. It shows me there's a lack of understanding about disability issues in this township. Heard a lot of totally irrelevant testimony based on case law that is not applicable here about cost, which is only applicable when it's a commercial building or a landlord is being asked to pay for the cost. There's no cases where the cost being a factor in reasonableness has anything to do with a person who owns their own home. All this extra testimony. I'm also really disgusted about how somehow when it comes to an accommodation for someone who's handicapped, everyone else feels like they can weigh in. And I'll admit I'm not really acquainted with zoning law. That's not my expertise as a lawyer. But I find it hard to believe that if someone's not disabled, that neighbors aren't chiming in on how they think they could do it better. I'm disgusted that people are questioning.
They do.
I'm disgusted at people questioning
They do
this
chime in, though.
this family's, they know what's best for their son. Every disability is different. Every person with the same diagnosis is different. And they have discussed with their doctors and people in their life the needs for their son and their family, which include a dedicated hallway, an isolated bedroom, and that's in their plans. The fact that these alternate plans by people that don't know this family, that don't know Gabe, are even entertained at all disgusts me. It disgusts me that you guys wasted 4 hearings on totally irrelevant things. You missed your holiday party. This family had to come in. I'm disgusted. I'm just really just disgusted. And I'm disgusted by the fact that if you guys deny this, there's probably going to be a Title II lawsuit, again, for the ADA, because it's your responsibility to, meet reasonable accommodations because you work for the township, and this is a reasonable accommodation and it's necessary. I'm disgusted that my money might go towards that. I'm disgusted that this township might be known as someone that wasted this much time, like fighting accommodations for a 6-year-old boy. And I'm really disgusted that there's people who live in this township that are willing to use their own money and time to fight for reasonable accommodations for a little boy and then delude themselves into thinking they're doing it as some paternalistic, benevolent way that their idea is better, because that's something that disabled people have to deal with all the time. Other people telling them that they know better. And the only thing I can say I'm not disgusted by is I have like a little bit of hope that there'll be a correct outcome and that one way or another, these accommodations will be addressed, whether that's through the township or through the federal government, I don't know. But Gabe needs these accommodations now, and it's already been established that delay is discrimination. So to further delay these proceedings or to make them go through an appeal is also discriminatory on its face, even though I feel really confident that they would eventually win that appeal. So thank you for letting me speak.
Questions, Carl?
I don't have questions for the witness.
John?
No questions.
Board?
No.
Anyone else? Go ahead.
Okay. Thank you. I know this is running late. I know you missed your Christmas party.
I don't care about that.
Well, I care, and I know it's been tense. It's a really intense subject. There's a lot of feelings on both sides. And I'm going to call my client, Lindsay Rockers, up just for 5 minutes to put a couple of things on the record. But the first thing I'd like to do is have something good.
Excuse me. Bye. I'll get the door.
Okay. Thanks, Ken.
And I was hoping I could put it up on the TV, but, and Lindsay can testify as the authenticity of this if it's needed. There's been questions about whether Gabe eventually will use his wheelchair, and I'm very happy to report that this week was the first time that Gabe was able to successfully use a wheelchair. And I have a little video, and when you see the pride on his face, it'll make you think back to the great things that have happened in your life. And I know he doesn't, we warned you he wasn't going to drive straight. But it's a great moment of hope this week, and it really brings home what we're here about. And so I'd like to call Lindsay up just to talk a little bit about the brand new exhibits that have come up.
Lindsay, you were smart up prior here.
Yes, yes.
And this video is accurate as to what the...
Yeah, that was his first time trialing any kind of power mobility. We're really proud of him.
You saw a couple of exhibits presented today. Can I touch your exhibits? Can you just briefly explain why this is not sufficient for Gabe?
Yeah, we would never do this plan. It doesn't accommodate Gabe, and if it doesn't accommodate Gabe, like, what's the point? Obviously, like, from the beginning, the first time that I came here, I talked about Gabe's need for a dedicated, separate like divided hallway. And his entire need for that is, like you saw, Gabe, he doesn't have like the use of like his arms to reach out and move a chair or pick up Legos out of his way. He's not even verbal at all to be able to tell us that something's blocking his path. So this is not a hallway. This is an imaginary line drawn down the middle of my house. Like, what am I supposed to do with that? Am I supposed to tell my kids, like, don't let your Legos cross the imaginary line. Don't leave your book pack in the imaginary hallway. You're not allowed to play in the middle of your living room floor. Like, I can't keep this perpetually clear. Like, the FHA says that you can't put an undue, unreasonable burden on administrative burden, but I feel like that's being shifted to me now to try and keep this space clear so that he can access all of his home independently. I would never be able to do that. I mean, I can't even, if I'm cooking here, I can't even see the rest of this space to know if it's clear or not, or if he's stuck on something. Like, this would never accommodate him. Not only that, but it doesn't give him the right to use his front door. Surely being able to enjoy your dwelling means that you don't have to go in the back like the help, right? Not only that, but they've moved us to the bottom floor. We have children that live on both the second and third floor, so like Mr. Schock said earlier, well, you're already living one floor away from your kids. Well, actually, I'm not. I've got 2 in the attic with me, right, or in the 3rd floor with me right now. So I'm not living completely separated from the rest of my kids. Also, this is our driveway right here where we park both of our cars. If Gabe is coming out of this ramp, he will never be able to get down this driveway past both of our cars to the ambulance and the school bus that picks him up and drops him off every day without pulling our cars out of the driveway every single time that they pick him up and drop him off every morning. This plan doesn't accommodate Gabe. I don't care if it costs $10,000 to do the whole thing. We would never do it because it wouldn't work for him. I'm sorry, I'm not trying to be aggressive. It's just frustrating and offensive and tone deaf that we've said over and over that he needs this hallway and that this is the alternative that was presented to us. So anyway, that's my thoughts about that particular
I just have 2 quick
alternative.
questions. One, you refer to the 3rd floor as the attic. Are you living among the rafters or is it a finished
No,
third
it's a
floor?
finished attic with a stairway.
Yeah.
I don't like pull down my drop down attic stairs to go to my bedroom. It's got a stairway to it.
And it's bedrooms and it's finished.
Yes,
Yeah.
yes.
And then the other concern that you expressed often was about where the 1st floor bedroom would be located. Does this satisfy that?
It directs all of the traffic, and like Ted said, he says it's short-lived that we'll be having kids coming in and out of our back door. I have a newborn, and unless the Kinnys are now dictating my family size also, we never said we were done having kids. We could have small children going out and that back door for who knows how long, at least another 10 years. And that puts it, Gabe, what, 16? Like, how long is he supposed to live with all of the noise and chaos and commotion right outside of his bedroom before it's unacceptable anymore for him to have to deal with that? Another 10 years? I mean, I don't know.
I don't have any more questions for this witness.
No questions.
I do request the opportunity, and I know I'm sorry it's late, to give a short closing because I really feel like there's a lot of confusion as to what the law is, and I really want to make sure that's clear.
We have a member standing holding the front door open, which he's happy to do. How long do you think?
10 minutes.
Okay, I'll give him some relief. And you want to do a close too, right, John?
I'll keep it to 5.
Okay.
Can I just say that their other alternative plan doesn't address these needs either?
Okay. First, I'd like to, any exhibits I haven't moved into evidence, I just ask that they be moved into evidence now. I think that's 18, 19.
19, through 19.
Okay.
It's not through 19 though, right? Because one that was remarked wasn't entered. Am I remembering that correctly? It was
17 was not it.
All right. I have just a couple of sheets for you to follow along. 2 weeks ago, I introduced you to Gabe Rockers. At that hearing, I learned Gabe likes to give high fives. And tonight, we learned he can drive, not straight, but a wheelchair, a powered wheelchair. In the end, this case is very simple. It feels more complicated than it is because it's in an area of the law that many of us are unfamiliar with. But it is simple. So I'm going to leave you with 3 points. 1, the facts and the elements support the accommodation. 2, I want to leave a clear point of the law. And 3, I want to have a little bit of perspective. The evidence supports the accommodation. Gabe has a legal right to a requested obligation if he's disabled. The accommodation is necessary to allow him an equal opportunity to use and enjoy his home, and the accommodation is reasonable. I think there's no doubt that Gabe is disabled. You have in front of you the definition of disabled. You have to ask yourself, does Gabe have a physical or mental impairment which substantially limits one or more of a person's life activities, major life activities? You've heard the testimony of his mom. You've met him. He's got multiple disabilities that affect all of his major life abilities. It's clear that we've met that standard. Necessary standard. The necessary standard is the one that's the big hang-up. I want you to turn to the second page. Necessary means the accommodation either would be necessary for the project's financial viability or would serve a therapeutic purpose. You can find either. If you find that this project serves a therapeutic purpose and it is therefore necessary to ameliorate the effect of the handicap. That's Lapid Laurel LLC, the Zoning Board of Adjustment of Township of Scotch Plains. That's the only zoning case the Third Circuit has taken on this case, on this issue. And that's the only one that's relevant. Gabe's mother testified that he needs to stay on the second floor as long as physically possible because his epilepsy causes seizures that require immediate intervention. His dysphagia could cause him to choke to death on his own saliva or vomit. The accommodation is necessary because he could die without it. Gabe's mother testified that the existing bathroom's too small and that the next size chair won't fit in the tub and that she can't get him into the bathroom with the door because of the way it swings open. It's clear that to allow Gabe the basic human dignity of bathing, the bathroom needs to be expanded. She also testified why the bedroom and expanded bathroom need to go on the side of the house instead of the back. And I'm not going to go through all that testimony because I know it's late. She also testified that at some point it's not going to be safe for him to be on the second floor. They're going to keep him there as long as they can. But at some point he'll be too big to evacuate in an emergency. So he'll have to move to the first floor. And he's going to need a dedicated hallway because you saw he's not going to steer straight. He's not going to be able to lean over and pick up a toy. He's not going to be able to call out to his sister and say, hey, you left your doll or your Legos or your jet plane in the hallway. He needs the dedicated space. Every one of the elements requested is specifically targeted to ameliorate the impacts of Gabe's disabilities so that he can have the opportunity to live in his home like anyone else. Matt Papa, I'm sorry, it's been a long week. Matt Papa testified that he's a contractor, and he said that he can do the plans proposed by the Rockers for $105,500. He testified that the alternate that was presented to them would cost $141,000. The neighbors expert testified that their alternate would cost $163,000, $58,000 more then they have a bid to do their own. You can find either that it's fiscally not feasible, or you can find that it's therapeutically valuable. In this case, it's both. You heard Gabe's mother testify that this is not an additional expense they can bear. She testified that if this accommodation is denied, the Rockers will either have to move from their home or place Gabe in a residential institution. That could not be more clear. The third element's reasonableness. And I'll just turn you to that, because this is a zoning case. And reasonableness is not, will it impact the light in the neighbor's window? The question is, and there's no evidence on the record about this besides the evidence I tried to present, which was denied, that you cannot find it's unreasonable unless it imposes an undue financial and administrative burden on the township. It imposes an undue hardship on the township, or it requires a fundamental alteration in the nature of the zoning program. There is no evidence presented to show any of this hardship or any of these burdens. And the burden is on the township to prove the accommodation is not reasonable. The township's not here. I guess the Kennys would like to step in their place, but they didn't present any evidence on this issue. It's the third element. It's the most important question. So it's clear. There's no proof it's not reasonable. So we got to assume it's reasonable. It ameliorates Gabe's disability by allowing him to bathe. It allows him to get from room to room in his own house. It allows him to have the solitude that he needs to sleep when he has to sleep significantly more hours a day than you or I have to. So it's absolutely clear that all three elements for the accommodation are supported by the evidence. And because the evidence supports an accommodation, you're bound to approve it. Now, the case law cited by the Kennys is the second point I want to get to, because every case they cite is an apartment-style use. It's where you or I live in an apartment, or anyone lives in an apartment, and they're asking for an accommodation in a common area, in the lobby, in the parking lot, in the parking garage, in the driveway. So obviously, there's going to be a different standard, because you're asking a landlord or a building manager to do something for you. And those cases have absolutely nothing to do with this case. In Vorsimer, it was a woman who needed a walker, and she wanted to leave it in the middle of the lobby. And what did the building do? They came to her and they said, here's 4 ways we're going to help you. They didn't say, you're doing this wrong, we're going to tell you how to do it. They said, you can leave your walker and we'll put it in the closet, and when you come back, we'll bring it for you. You can take one of our staff members to your car. He'll load it into your car, and he'll take it out of your car when you get back, and you can use it. They told her, you call us. We'll put the walker in the closet. You tell us when you're getting there. We'll meet you at the curb, and we'll help you. They told her, you don't have a valet spot? We're going to give you a valet spot, and you can leave it at the valet stand whenever you want. They said, we have empathy for you. We understand your situation. This is how we can help. And they did it. And that's why they found that it wasn't reasonable for her to just leave it in the middle of the lobby, because her landlord was actually helping her. Same thing with the other cases they cite. Resnick, they wanted to remove a speed bump because their car couldn't go over a speed bump because of their handicap. They said, okay, we'll remove it. We're not going to remove all of them. We'll make sure there is an entrance that works for you. In Temple v. Hudson, same thing. Family has 2 cars. They request a handicap spot for 2 cars. They say, we have empathy. We're going to give you a handicap spot, but we can only give you 1. And they gave them 1. It's completely different. It's asking the building owner to make an accommodation. So I just want to make it clear that all these cases that are being cited, all these cases that are making us juggle all these new plans, a new plan every meeting, not given in a way that's designed to help the Rockers, but given in a gotcha way, trying to thwart their accommodation. All of these things are completely irrelevant. And the last thing I just want to talk about is just a little bit of perspective, because this has been hotly contested, and I know they're frustrated and angry. I know that they're hurt. I know there's a lot of pain involved in this case. And so I want to just take a deep breath, and I want to ask ourselves, what's the impact of the proposed accommodation? And I got a little visual cue for you. It's 4 feet. It's 4 feet of pavement that's going to go away, and we're going to have a 17-foot 8 boundary between the two properties. You know what? I don't know if I'm even going to make it. So there's 17 feet, and here's 8 inches. Up here, I can push it there. We're talking the width of this desk. 4 feet. This is in a neighborhood where there's twins across the street. 4 feet out of total 21 feet, 8 inches that separates the two houses. 4 feet that will leave 17 feet, 8 inches separation between the two houses in a neighborhood that requires 16 feet. 4 feet on the Rockers' property. 4 feet to allow a 6-year-old child to stay home with his family and be able to use and enjoy his home. At the beginning of this case, I told you I was going to ask you to help Gabe. It's a simple case. It's an easy decision. The only right decision is to grant the accommodation, because Gabe's a child in your neighborhood, Gabe's a child in your community, and Gabe needs your help. So I ask you to vote tonight to grant his accommodation request. And I thank you for all the attention you've given to this. I know it's been stressful. I know it's been abrasive. And hopefully it's over and we can all have a peaceful Christmas.
Members of the board, to begin, thank you very much for your time over these past 4 evening hearing sessions. I just handed out a case to you with a short brief, and it's related to the first topic I wanted to talk to you about, and which may be a critical topic in this whole analysis. So at the very beginning, we're, as a board and as applicants and objectors, concerned about what law applies here. And I had initially been under the impression that for certain that the Federal Housing Act applied and that there was no question that the ordinary variance standard didn't apply. But as I was involved in the case, I continued to do research, and I wanted to bring to the board's attention this Pulcinella versus Ridley case. It's a case out of Delaware County. Very, very similar to this case in the sense that it involved an allegedly handicapped person who was looking for a side yard variance to do some construction on the property. And in that case, the court determined that the FHA didn't apply. And the reason the court said it didn't apply had to do with how the act is structured. So there's two key parts. There's Section 3 and Section 4. Section 4 has all the stuff in it about when there needs to be accommodation, including when a ordinance needs to be adjusted or a township needs to adjust its rules. But Section 3 talks about when Section 4 applies. And Section 3 says it applies essentially when there's properties that, there are at least 3 properties owned by the persons involved. And so the question then arose in this particular case, the Pulcinella case, where the property involved was only a single property, and there was only one property owned by the involved parties. There wasn't at least 3. And the court said, look, we have to look at Section 3 that tells us when Section 4 applies. And Section 3 tells us it only applies if there's at least 3 properties that are in the ownership that's involved in the proceeding. So I think there's a question mark as to whether the FHA applies. Now, I will also say that there is other authority. I couldn't find one that dealt specifically with a zoning case involving a single-family home, which is a perfect matchup. There are other cases in other jurisdictions where courts have applied the FHA to a similar situation. But I was concerned with what the Pennsylvania Circuit Authority was. And the Pulcinella case hasn't been overruled. And I haven't seen a case involving appellate authority that relates to those specific facts. So I say that because, and unfortunately, Lucas, this may fall to you, but there's a threshold question still in my mind as to whether the FHA applies. But my argument tonight is going to say, okay, let's assume that it does. Where are we? And boy, I understand the emotion here. I certainly understand, although I can't appreciate it from personal experience, the rocker's concern. But I think there's a proper focus here, and it's to focus on the most essential element of what requires FHA relief, and that is that necessity component, because it's from the question of whether an accommodation is necessary that everything else flows. And it's the reason why in the first short memo I gave you, I referenced that case that talks about, and the court went on and on for pages to talk about what is this necessary, this word that's in the statute, what does it mean? And the court was giving many examples, some of which Carl talked about, that essentially said, if there are alternatives, then that a particular accommodation is not necessary. The accommodation to be necessary has to be essential. I mean, it has to be that or nothing. But if there are other alternatives, then we haven't met the standard, the requirement that something be necessary. So it's the focus, and it has to be the focus, I think, for the board, and it was also the focus of what we tried to present to you. It's a tough spot to be in a neighbor. So you've got this in front of you, and you want to, in the Kenny's case, their home is their castle, just like it is with lots of folks. And the idea of having a property now, although it's minimized, to lose half of the setback is consequential. So the question is this necessary, and the effort? And I think the evidence pretty persuasively shows if you put your thinking cap on, there's other ways to do this. Whether it's the Steve Schock suggested way of trying to have a rear-only addition, or if it is the Kenny 7 way of saying, okay, let's minimize, let's give them a hallway, but let's minimize it. Let's draw it in, but let's put it as a one-story and make it limited. There are alternatives, and if they're all alternatives, and we demonstrated that they are, then the necessary component hasn't been met. I accept that Mrs. Rockers was in front of us in all good faith and doing her best to describe and give you the evidence that you need. But it is a big gaping hole that we didn't hear from an architect, right? To be able to say, look, you came up with a design, but did you consider this? Did you consider that? We had pieces of paper, and we had a design, and all we could do is address that design and put on our thinking caps and say, oh, there are alternatives. And I think instinctively, you must feel that with this property, with this massive rear yard, that there's a way to do this that accommodates Gabe's needs, but doesn't require that the setback be intruded upon. So Mr. Schock testified about an alternative. He didn't say it was the only way to go. What he did in the time we had, and with the opportunity he had, and what he could know about the situation, he came up with an alternate design that's functional. In Kenny 7, there's an alternate design that's functional. Questions that the board asked suggested to me that there's an inherent appreciation that there are alternatives, that this is a property that is crying out for some good thinking, and not for saying, this is the one option, this is what we want, therefore it's what we're entitled to. If we look at what was presented by way of medical evidence, certainly Gabe is disabled. Nobody's debating that, and he's in a sad circumstance. I did take particular note as to what was presented by way of evidence from a professional, and that was the letter that was submitted by the doctor. And the doctor's focus was not on a hallway. He shouldn't say a word about a hallway or a clear path. What she said was that he needed a larger bedroom and that sort of space. And, I think that that's the medical focus, and that probably ought to be the design focus. But whether that's the singular focus or whether that's an alternative focus, there are other ways to approach this. To harken back the case that I gave to you in the first time to talk about what a applicant is entitled to under the FHA, the word that the judge decided to use was, it's not necessarily the preferred accommodation that's required. It's an accommodation that will address the needs. So there's a difference. The court's saying to us all, look, we're out here trying to do what we can to accommodate the disabled. But if there are alternatives, if there's something that's preferred by the applicant, but there's other alternatives, then you're not meeting the necessary standard. The last things I would say is, and I said this before to you, and I meant it. One of the things you have to be wrestling with is the price tag on all this, right? Because if you were convinced that there's no way to do an alternative option that wouldn't be excessively more expensive than what the Rockers proposed, then you may have a concern. So a couple things to think about. Mr. Papa testified. He didn't cover some things when he estimated the cost of the alternative, rather when the Rockers submission didn't move the driveway, no lift, no ramps. There are other things that were missing. When he considered the alternative design, he had it up at 1,000 square feet, which is like only a third more than it really is. And then we bought in so that you have something to be able to depend on, an estimator that talks to you about relative scale. So yeah, his numbers are higher, but what he's saying to you is, look, everything should be about the same price. If you had three alternatives here, Rockers, Shock, and Kenny 7, all of them should be about the same price. So if somebody can do it for $125 a square foot, like they can do the Rockers design theoretically, he testified you should be able to do it, the other two designs, for the same price. He gave you reasons by saying, look, this is a much less complicated application if you're doing a rear only. And I think instinctively you know that. If you're only dealing with one roof, if you're only dealing with one side instead of three sides. So I would urge you, when you're considering this as an entire package, and you're saying, okay, are there alternatives, and do we have a great concern that we have an economic disparity? I'd say number one, think hard about how the numbers shape up from the testimony of the estimator. That if everything is going to be about equal, and if you look at this and you say, okay, I can see it's about the same square foot, and I can see it's a similar configuration or maybe a simpler configuration, and I think you can reconcile that and say, we are not sentencing the Rockers to spend a lot more money to say to them that there's an alternative. And so I leave you with that. The issue is one of necessity, and that is the guidepost of the FHA, and if it's the FHA law that applies, then in this instance, there is not a necessity for an intrusion into the side yard. Thank you very much.
I also have some case law for you. Just gonna hand that up. Can I have your case, John?
Thanks. Oh, I think I gave you one. Didn't I slide it down? I'll give you another one.
Carl, do you have any?
And you admitted applicants 18 and 19, is that correct? Yes.
Yes.
Applicants exhibits 18 and 19, he moved for their admission.
Yeah, he did.
Was there any objection? Yeah, correct. Was there any objection?
No. What was it?
18 was the memorandum from the Department of Justice and the, and Housing and Urban Development.
You introduced that as an exhibit, not just kind of.
I believe so, yeah.
thing?
A18 I had it as.
I think you guys marked it as an exhibit, and that's fine.
Yeah. Yeah, okay, all right.
All right. Any other administrative matters that need to be addressed before we close the hearing? All right. So we're gonna, was trying to figure out what our first hearing date in 2020 is gonna be, because we can't do a decision tonight. Can't have voting members sitting out holding a door.
That's to make sure.
Not that we would be able to do it. So our first meeting for 2020, our next meeting, is going to be maybe January 9th, or we'll have to schedule a special, we're not sure of the date, is what I'm getting at. So I like to announce a date specific, but we just don't have one right now. But it will be, the decision will be rendered at our next regularly scheduled meeting, which will be the first meeting in January of 2020. So with that, we'll close the record on this case. The decision will be rendered at that time. Thank you.